Because the attorney is here and I'm here, but on that matter.
Maybe after the fresh matters minutes. Your Lordship will take it after the fresh matters minutes. Today it's listed today minutes. Please.
Shall I mention a matter pertaining to my lord, the demolition of chambers?
Mike.
That may I mention a matter pertaining to my lord, demolition of chambers in Lucknow, my lord, lawyers' chambers. I'm requesting that it be taken up tomorrow. They have given notice for demolition for 30th, my lord. I'm requesting it may be taken up tomorrow, my lord. The SLP has been filed, defects have been cleared.
Contest first of all, and why can't you go to High Court?
My lord, High Court has passed, my lord, in a criminal writ petition treated as PIL passing the orders, my lord. High Court has passed the order.
High Court has passed on judicial side.
Please, my lord.
Must be unauthorized chambers.
Please.
Must be unauthorized chambers.
My lord,
Why any sanction granted?
my lord, we are there for last more than 40 years, my lord.
That's the whole problem. Huh? Oh, yes.
I'm only requesting to be taken up tomorrow, my lord. But they have given notice for demolition for 30th.
Contest that notice. Notice is for 30th. You will file a reply on 30th.
My lord, that will, no, they say that we are coming for demolition. Their notice says we are coming for demolition.
Who can dare to touch the Lucknow lawyer?
The notice says clearly that it's for demolition on 30th. Tomorrow, my lord.
May I mention, my lord, the matter with regard to co-option, my lord, in the State Bar Council. Lordships passed an order, my lord, on 4th of August that there should be, my lord, a senior member of the bar and the High Court judge. Now, the High Court judge of the jurisdictional court cannot be there because there is a bar under 220, but that's a different thing. The my lord, problem is this, that probably it was not pointed out to your lordships that in Shiv Kumari's order, after referring the entire issue to Justice Dhulia committee, because how it should be done was not clear. So lordship passed an order saying that all these things will be decided ultimately by the committee. Now, committee submitted the report. Bar Council of India submitted the report after, my lord, hearing all of us. I am representing, my lord, six states, those who are number 6 and 7. Now the question is, my lord, ultimately it's a body, and if a lordship's direction, then my lord, those reports should have been considered.
No, we have considered.
Justice Dhulia committee report, my lord.
We have considered everything. We are not going to.
Under Article 142, when the Advocates Act says, my lord, a particular thing, can an order be passed, my lord, contrary to the Advocates Act?
Why not that order?
Under 142, 142, my lord, lordship knows.
Earlier order was passed by whom?
Earlier order was, my lord, it's a, my lord,
a special, a kind of a concessional provision which we have introduced through judicial PA. Now it's being claimed as a matter of right that option should be like this, option should be like this.
No.
Every day there is a mentioning, giving a new dimension, new criteria before us. So therefore we can't entertain.
I am not going beyond, my lord, lordship's directions. Lordship's direction was very clear. Only one second. Very clear, my lord.
Our direction is very clear. That is
no, my lord, it said that Justice Dhulia will finally decide this question, and the report came. Now, once the report came, my lord, the report should have been looked into.
We have considered that report. We have also considered 3 options given by Bar Council of India, and then we have taken a conscious decision.
That probably in the order it didn't come, so therefore, my lord, it was not clear. If your lordships have considered, then naturally.
We have considered, Mr. Malik. I can assure you. After all this, everything is Genesis is our orders only. Everything is originating.
Yes, my lord. I bought on, my lord. No, it's a great thing in the sense that women representation came.
There is no end. Every day there is a mentioning. Every day there is a news.
I didn't know, my lord. I didn't know. To be very frank, I wouldn't have mentioned.
No. Yeah. We are telling you because you don't know because you are mentioned. You are first time mentioned.
When I was told when I came here that Tamil Nadu mentioned. That's all, my lord. My knowledge is.
Mr. Parikh, take it from us. Every day.
I will take it from you.
And every day new criteria is being suggested. So it is very difficult for us also to make
May I make the last one, which your lordships may consider, because
what we find you have what you have just mentioned if that is so, then it will carry some weight. You have said that there is a constitutional bar.
Under Article 220, so therefore, my lord, the judge cannot practice, jurisdictional judge. So therefore,
Practice will not be.
no, my lord, it is, cannot plead practice. Ultimately, it is advocate's body. So you bring in a judge, jurisdiction judge, there is a bar. So therefore, my lord, must have some advocates who should be not the judge.
Some chief justice.
Mostly, Mr. Parikh, the chief justices are from outside this. Most.
No, I am not, my lord, but lordship has said jurisdictional judge, retired jurisdictional judge. The term used is, lordship may consider that, I am just leaving at that, according to me, my summation.
Outsiders just we may not prefer. Outsiders just
Yeah,
we may not
yes,
prefer
correct,
because there
correct.
will be no use of that.
Absolutely.
Let us wait. If some chief justice makes such a reference to us, we will examine that. This part we
I
are
think-
open to.
That part will not lordship may examine.
Because you are pointing out something new, which may be an impediment in constitution.
Yes, my lord, yes.
Therefore, we will consider that.
Lord,
Rest of the Mr. Parikh, please understand our difficulty also.
my lord.
Milods, may I mention?
I am also
Lordships kindly.
similar matter, Milods. I am also
Regard
mentioning a
Samal-
similar matter.
Samarov's Milods, there are another 150 to 200 cases, Milods, which belonging to under, which are covered by global milk case, Milods. Can I submit those lists by end? Can I?
Yes, yes, yes.
Milods, may
I am also mentioning that lawyers matter, Milods.
kindly grant, by the end of the day, I'll give it.
Everyone will entertain everyone, please. I will entertain.
May I mention, Malod, sir?
Everyone is pointing out something. We want to.
I am mentioning that lawyers method,
I'll give the list by end of the day, Milods.
Milods, I am mentioning that same matter, Milods.
He is pleasantly increasing our figure of today's hard work. So let us first give preference to him. Besides being that his constitutional right of first audience.
Malod,
Yes, Mr.
may I-
Choi, what is
Please,
there?
Malod, sir. Malod, urgent listing of an SLP. I file a writ petition before the High Court asking for a CBI investigation against an officer. The High Court, Malod, directs certain private parties to be now impleaded in the matter. Against that, Malod, how can private parties in a public interest cause, Malod, sir? Malod, only, and it's coming up, Malod, on a short date.
Set aside that order.
Well, that's the problem, but the difficulty is, Malod, if those proceedings will get derailed, nothing will come out. Allegations and counter allegations. So I'm only listing on that one little, on one that
For the private party.
I am the petitioner. I am the writ petitioner in that. I am objecting, Malods, the inclusion of these interveners. They are all private bodies and they are benefiting from that.
And the High Court has said the benefit.
They are the ones who are being now heard, so that there is some counterpunto on the other side to be opposing us.
Also, because beneficiaries of the crime or any misdeed, they should also be party to it.
So, Malods, if you lodges may just hear us,
I am not
show material.
attacking you, because you are going there, you are espousing a cause.
I
where-
don't know who the High Court is helping, Malods, at the end of the day, lodges may have it, Malods, I'm not sure.
The notice if you come to know, so let them
Sorry.
consider.
Consider, Malods, having it.
No, we are only examining from tomorrow's angle, because tomorrow there is a rush.
That is right, I know.
That is, if there is unless there is an extreme urgency.
Malods, on Monday, then. Your lodges may have it on Monday, Malods.
you can-
Very well.
But
On-
first, whenever you want.
I'm grateful.
Your
On
Lordship,
Monday,
I am-
deeply obliged.
I am-
Grateful for that.
Lordship in matter, Lordship. Your Lordship,
Milods, can I, Milods,
Milods, I am also
can I-
mentioning,
as I'm troubling your lordship, a judgment on Friday disqualified me in a tender on technical grounds, whereas the same judgment division bench had held the same memorandum valid to me. Now, I am only asking for a listing tomorrow because they will otherwise go to the financial and close it. Judgment is on Friday, Milods. I've got a full number, SLP 3C,
Tender will be finalized.
this week, because now I'm out. Now they will only finalize the financial. They have to open only the financial. I'm excluded on my technical. Towards the end of any board tomorrow, Milods, if possible.
Lordship, if I may mention a matter, this is a fresh SLP, Lordship. What has happened is, sorry,
Sir, let me give a date at least.
sorry.
Lordship.
Give us the note, Mr. Sipal, if you.
Oh, very well, I'll give a note.
Milods, may I?
Yes,
Obliged.
Lordship, in this matter, I am the wife of I'm a Belarusian national. My husband is a Indian national with 80% disability. He's bedridden. A deportation order has been issued against me, which the High Court has affirmed. I'm just pressing if the SLP may be listed tomorrow because there is urgency by virtue of the deportation order. And if I am deported, then, my husband will have nobody to look after him. Of course, on the law also, I have submissions to make. But I'm just pressing if it may kindly be taken up tomorrow, the SLP.
Going to deport in a day.
The FRRO, no, Lordship, not in a day, but the rest of the days are holidays this week. So hence, if it could kindly be taken up, because otherwise they may go ahead and take.
matter of 31st or 1st of September. Nobody is going to deport like this.
I'm,
Deportation order in this country are not executed for years.
if I can only request if it can be taken up tomorrow, otherwise I'm in my lord's hands.
If we don't think that there is any extreme emergency for tomorrow, we'll list your matter on 31st. You can point.
All
out
right.
the file yourself.
With my lord's permission, this is the Indian, my lords, may with the
permission,
Indian
may I-
Coast Guard matter, my lords.
Your Lordship, if I,
With,
with
Your Lordship,
permission, may I mention? My Lord, may I mention the urgent listing of a criminal writ petition? This relates to one Mr. Abhishek Upadhyay, the journalist who broke the story of the theft at Ram Temple, my lords. Thereafter, multiple FIRs have been filed against him, and now FIR under the stringent sections of SC/ST Act has also been filed. A police party has raided his house on 20th. Yesterday also police has come at 5 o'clock. I could file my writ petition. I request, my lord, if it may be listed today or tomorrow, whatever, my lords.
with my lord's permission, my lords, this is the,
Tomorrow.
Yes, my
with
Lord,
my lord's
Make sure that defects are.
Yes, my Lord.
Lord, this is the Indian Coast Guard matter, which Lords had heard the previously. Now, the Indian Coast Guard matter, my Lords, for permanent commission previously, which was heard, my Lords had listed it for 10th. The last date, as per the new policy, what they have brought out, was 10th of September. Now, on Friday, they came up with a new letter saying that you have to submit your documents for showing willingness by tomorrow itself. So from 10th September, after my Lord's order, they have shifted the date also. Now I'm nowhere, my Lords. So the worry here is that if I submit the document, they say that I am agreeable to the policy, which has to undergo 4 tests.
Nothing. You have pointed out to us, that's all.
Very well, my Lords.
With your lordship permission, may I mention early listing of Civil Appeal 6230 of 23, your lordship. This is, your lordship, in this, the urgency is the DM quota has taken the factory asset. This pertain to workers, 1200 workers, become remediless, your lordship.
My Lord, may I mention, my Lord, tomorrow
And
it's
the
connected.
court has given the liberty.
My Lord,
Please make a mention. The petitioner here has filed an SLB. He's a UPSC aspirant, and he is a UPSC aspirant. He had cleared the preliminary exams for UPSC and the state examinations as well, and both the mains were falling on the same date. My lords, he had to forego one of the
This kind
state.
of situation is bound to arise.
Your lordship, if you may
It's not
please.
administrative issue. Nothing can be done on judicial.
Your lordship,
What
but
have you-
there is an administrative lapse in it. I can show it to you.
We appreciate your concern. Probably on that day in Lok Adalat also. you
Yes,
made a
your
mention
lordship.
of it. It's not that we don't apply. Later on, I personally thought of that, the issue, what is the issue
Great.
and what should we do? And can we do anything? If UPSC, suppose there is a state public service commission exam, there is a UPSC exam. First issue will arise, whom we should direct to postpone the exam. Your exam can't be conducted after 1 day or 2 days. Entire exam will have to be postponed. Entire exam means lakhs of students.
Your lordship.
What will happen with them? Then suppose state public service commission will tell them to postpone the exam. Some other state public service commission examination will come. What will happen?
Your lordship, if
It
you
is
may
not an
please.
issue that we can resolve at
Just
judicial side.
My lord.
one submission, your lordship, but just one submission that I'd like to make, your lordship. I'm not seeking postponement of any exam. Your lordship, I'm only seeking defer the examination for the petitioner. Please have,
How can it be?
because
How
after
can we separate exam for you?
he has received this opportunities after 8 years. And he has been representing well within time, your lordship, from June itself.
That you take next year exam then.
I have it for hearing.
For God's sake, how can be there is separate exam for you?
May I have it for hearing it?
Take to other than to again.
My Lord, may I mention, my Lord? Where your lordship was in regard to examination of the students appeal. Connected matter is listed tomorrow at serial number 27. This is also in regard to the admission or examination of the student, BSc examination, my Lord. The examinations are going to be held on 30th.
That is coming tomorrow.
Lordship, serial number.
Lordship, may I mention a matter, please? Item number 38, which is Mollinge Road versus State of Gujarat, which is listed tomorrow, Lordship, with 3 IA is already listed, but my IA is not listed. Kindly also to be listed, my lords.
Yeah, IA is also such a headache.
Lordship, land allotment. Matter.
Your lordship,
Gandhinagar.
your lordship,
With my lords,
Lords,
with my lords,
scheduled tribe student, my lords.
with my lords.
Eviction matter. My lords, this is an eviction matter, my lords. The learned executing court is proceeding with the execution tomorrow, my lords. So if I may request.
When was the order passed by High Court?
My lords, it was passed on 11/8/2026, but the order was uploaded on 7/8/2026 only, my lords. Already the learned trial court has.
8 is the order and 7-8 uploaded.
17/8, sorry, my lords.
Lord, Your Lordship,
I've already filed it and all the defects have cleared. SLP is registered, my lords. I only request if it can be listed tomorrow.
Lord,
Because, my lords, the holidays are coming up. That's
Your Lordship,
the only difficulty.
With my lords.
Lord, I had mentioned a matter on Friday where Your Lordship. Lord, may I mention a case of anticipatory bail, my lord, where condition of 1 crore cash deposit was fixed. Your Lordship had allowed mentioning for today, my lord. Out of 3 matters, only 1 is listed. The other 2, my lord, may be listed tomorrow or today, my lord, subject to Your Lordship pressure.
No, anticipatory bail.
Yes, my lord.
All like tomorrow.
My lords, my lords.
Student, my lords, admission matter, my lords. Scheduled tribe student, my lords, admission matter. He has been granted time only until 4th of September to submit his validity. To other castes, my lord, the state has extended that time for 6 months.
Can you still matter on 31st or 1st?
My lord, tomorrow, my lord, because 4th of September, that deadline is there, my lords.
With my lords,
On Monday, my lords, then 31st, my lords.
with my lords' permission, may I mention an
That
article?
bar council matter, my lords, I only wish to, my lords, point out 2 more issues, if your lordship permit me, in that bar council matter. That's one is the affected parties were not, my lords, heard in this. It is sort of the affected parties, that is 6 and 7. In series, my lords, that is one.
Parties are not being heard.
They were not being heard, my lords. 2, my lords, that do, my lords, my lords, we were not present. The affected parties across the country.
No.
We didn't hear them.
6 and 7, my lords, 6 and 7 are the affected parties.
Discussed.
2, my lords, another aspect
When
is,
are you affected?
my lords, because,
You have a right.
my lords, after,
When you have a right.
can I,
When a stove
Yes,
is
my
when
lord.
where is your right?
I will just submit.
It's your right to be co-op.
I'll just submit, lords. After 100 years of struggle, my lords,
100 years of
of
struggle does not create.
lawyers got their,
The
my lords,
right
autonomy to choose
This
their,
came from orders of this court. And orders of this court make it very clear, it's a discretionary jurisdiction of the Chief Justice. So you have no right.
Can
So
I-
there is no question of hearing.
can I just, lords? Because this, my lords,
One thing similar to
this,
that
my lords,
matter,
was
I'm
after
appearing
100
to
years
tell you-
struggle, we got Advocates Act.
Thank you very
Lords,
much.
one more thing, lords, there is one more thing, the Dhulia Committee's report has not been given to us. So at least that should be given to us so that we can challenge. If there is a recommendation which is contrary to the democratic principles, we can
In
challenge.
our order.
With my lord's kind permission.
Lords, my lords,
You want it for academic purpose?
No, my lords.
Yes.
No, my lords.
If you
we
want
will-
it for a cause
No,
of
my lords,
action,
we would like to challenge that. My lords, secondly,
Why we have made it.
my lords,
clear
there
to
is
you,
an,
sir, to permit you to challenge.
no, my lords, there is an earlier order of this court only that Dhulia Committee's report will be final.
We have not appointed just Dhulia to allow anybody to come in court and comment on his report.
No, we are not commenting upon his report. Maybe that is in our favor. We can point that out to my lord. But at least we should have, my lord, something very substantial has been
My lord's kind.
taken away from not only us, the entire bar. Now, my lords, we don't even know whether,
But you will tell.
My lords, if I may request.
where is the way out, my lords, may kindly guide us then. What do we do? My lords, because there is no provision in Advocates Act to nominate, my lords, that's the biggest difficulty. If there is no
Is
provision,
there any provision to give reservation to women?
my lords, but that is within
Is
the,
there any provision to give?
yes, my lords, there is a provision because
The provision
elected members,
was
elected members.
created on Article 145.
Only elected members.
Gupta and all
There is
this
no provision of nominating.
I'm so grateful, lords. Lords, may I mention a matter?
Like this only, my lords.
Lords, if I may
One last
My
note,
lords,
what
one more
Mr.
thing,
Pracha is
lords.
saying, my lords, it was
Can-
very empowering that the honorable court passed that order. Empowering the woman, saying that, yes, despite that you may not have sufficient votes, you can get elected to the body. It
And
was,
women who are chosen.
well, I just want to add that, but at the same time, it was very disheartening for the woman to say that only so much of you can come. Just 5 of you can come, not all 7 of you can come through election when the section 3 itself says it has to be an elected body. That's the only condition that is there in section 3, that it has to be an elected.
Lords, may I mention?
Why not? Because there is
Give us a hearing, my
through
lord.
election. my lords.
With my lords.
Why there
Give
has
us a hearing.
a nomination.
Lords, may I seek liberty
Give us a
of this
hearing.
honorable court to mention a matter?
Far-reaching consequences, my lords.
With my lord's kind permission, lords, may I mention a matter?
In the order. All right, now, thank you very much. Let's start.
My lords,
Lords, can,
my lords'
may I mention a matter with my lord's kind permission?
My lords, if I may
With
request.
my
for
lord's kind permission,
With, Let's, may I mention? Oh, sorry.
Your Lordship, a fresh filing matter, Your Lordship, it may be listed on opening.
No, what is the matter?
Your Lordship, the petitioner is an officiating Anganwadi worker and he's.
We will hear, but what is the urgency? We just want
He's
to.
going to be relieved from his, she's going to be relieved from her duties
Next
during
week.
this.
With my Lord's permission,
The list of pending matters pertains to Jaufor matter. Jaufor bench. We have asked for the
with my Lord's permission, may I
the
mention,
list of pending matters. Still showing. Yes, yes.
may I mention?
Let's, may I mention a matter
50 matters.
after him?
With my Lord's permission, may I mention an Article 32 petition by a sitting lady member of parliament who was evicted from her constituency accommodation, my lords, by local officials, the additional district magistrate and the district magistrate, in the dead of the night at 11 p.m.
High Court.
My lords, this requires, my lords, in our respectful submission, some comprehensive directions because it involves, my lords, this involves issues of federalism. It also requires an independent investigation. And this has happened, my lords, despite the High Court already having passed protective orders. So this is happening despite. My lords, I am only praying for listing on an early date because this involves an important constitutional issue, my lords.
Please keep it yourself. We are not going to entertain.
Lords, I'm just putting a matter for kind consideration of this honorable court regarding that 20th July Jantar Mantar protest. I'm just seeking, my lords, I'm praying, my lords, to take sumo to cognizance of only one aspect. The matter is already seized with, my lords. Where the sexual assault, where the girls are claiming that they have been sexually assaulted in terms of maybe lathi was jabbed into the buttocks or some other instances which are so heavily reported on social media. I am beseeching my lords to take sumo to cognizance.
These are subject matters of repetition themselves.
My lords, these are the instances.
Independent writ petition was filed.
Allow me
with
to-
regard to alleged violences on the basis of.
Allow me to complete the submission. I'm requesting my lords to take standalone the sexual assault cases to constitute, my lords, maybe not a committee, but appoint a district judge, designate someone so that the girls can actually send their complaints directly. And those sexual assault cases can be taken up.
Madam Shobha, in the order which we have made reference to the committee, this issue is specifically mentioned. This is specifically mentioned. Number one. Number two, priority basis.
Interim
So, in fact, two issues we have requested the committee immediately take cognizance and to submit an interim report. You may be justified.
My concern is about how would the committee is going to get the complaints. Complaints, an order which says that they can, an email ID is provided, a designated officer is designated, to whom,
So, what we will do, we
and it is
appreciate
given a publicity that
We appreciate your concern. In the order, we have permitted the chairperson to appoint a nodal officer, a judicial officer as a nodal officer.
my lords, please.
We will see that if they have appointed, then we can send a message to the committee to notify so that all those who have grievances, they can at least directly submit their complaints to the nodal officer.
That's my precise concern. The instances to reach to the committee. I'm so very grateful. I'm so very My grateful. lords, I'm so very
Lords,
grateful.
my only request was that my lords will just kindly examine it. My lords will just kindly examine.
Malaj, if I may just request for a reconsideration of this eviction matter, Malaj, because it's proceeding with, Malaj, the SLP may become infructuous, Malaj. On 17th, the order was uploaded, we filed the SLP on 22nd.
To create hype in court, that's all. We are telling tomorrow that there is a huge rush of matter. Please wait for, we will list your matter 31st, whenever you want.
Deeply obliged.
Give the details, we will list it.
Deeply obliged.
You know, may I mention anticipatory matter, my lord? That anticipatory bail matter, my lord, that was dismissed by the honorable, but now High Court, my lord, but ultimately, my lord, that order was passed without looking at the affidavit filed by the state, my lord. My lord,
you are seeking anticipatory.
Anticipatory, my lord, because the entire dispute is regarding the registration on the documents.
Have you filed your petition here?
Your Honor.
You have filed SLP.
Yes, Your Honor.
You have cured the defects.
Yes, Your Honor.
Ready for listing.
Yes, Your Honor.
All right, tomorrow.
Lord, deeply blessed.
There is one mentioned.
There is a IA has been filed by us, my lord.
My lordship may kindly permit me to mention My lordship, there is an SLP which I have filed. My lordship, the urgency is that a recovery is ordered, my lordship, of 6.7 lakh rupees, my lordship, commencing after 1st of September, my lordship. My lordship, I have cured all the defects and court fees, my lordship, but the scrutiny section has held up the matter since the last 1 week, my lordship. So, my lordship, my humble prayer, my lordship, is
What is your
my lordship, even a letter of urgency, my lordship, I have submitted to my lordship's esteemed office. My lordship, on Saturday, my lordship, the letter is.
Mr. Babu, we will see I think 2 days back also you had made a mention.
My lordship,
We will examine.
my grateful, my lordship.
This was awaiting indoor development. This was covered.
It will be covered.
Yes. Development.
Are you appearing in item 1?
I'm appearing on
The petitioner has filed an early hearing with us. The
Petitioner
petitioner has
has
filed an early hearing.
It's an early hearing application, my lord. Because, my lord, kindly see in the early hearing application, page number 6, my lord. This matter may be listed after the indoor development matter, my lord. It is not listed, my lord. I am just requesting.
It seems to be covered by that. Alright, list on so. So, listing the miscellaneous things.
Oblige, my
For the state of Tamil Nadu.
Item 2 is also an application for early hearing matter.
It's an early hearing matter. There are officers, manager of the railway coach factory who have been accused of negligence and being complicit in an accident which happened completely inadvertently. And my lord, sanction was refused by us, which has then been challenged. My lords, at any date, my lords may hear this because, of course, there are officers involved.
There is already a stay in your favor.
Yes, but my lords, nonetheless, my lords, these are officers and the sword of Damocles is on their head. And when we don't think that they're involved at all, and we refuse sanction, but nonetheless, it's been challenged. Any date, my lords, at any date of convenience. Obliged.
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 Please, Manoj, this is my early hearing application. I'm only praying for any, subject to convenience of my lord, any date of this day.
Wait for some time, please. And I think at 2023
It's retired, all emoluments. In fact, before passing of the stay order, my lords, it will be listed in September sometime, my lords, any.
Item 4.
May I please, Your Lordships? Lordship, this raises a very serious issue when it appears that private companies are actually selling private personal information, which includes not only my employment history.
We have some other issue also regarding.
Lordship, the shocking part is that actually advertising that they have access to the EPFO records and the ITR records.
Consider your presentation.
Would the Lordship consider issuing notice so the state can also, because what we have done is we've written to the state.
Otherwise, what will happen? So many.
We've already written to the authorities. We've given two representations to the union government.
Direct them to consider that presentation, take a call on that.
Lordship, my only concern was if it would be under the aegis of your lordships, it kind of has it gives it a little more impetus. That's it. Because ultimately, this is thousands and crores of people's personal data, which is being sold at paltry sums. 200 rupees for my ITR returns.
Some architecture has to be developed by the digital repositories under the DPDP Act.
Lordship, something is fishy here. Why I say that is because what is happening, I have my learned friend here, she has personally... I'm so grateful, Lordships. Lordship, would your Lordship consider meanwhile...
Probably get a solution also. You have prepared a detailed representation. It's better that we get a time-bound consideration for that instead of, then what happens is this writ is there. Then it goes on, notice comes, and by the time it is taken up and decided, you would have got the relief also.
What question is of
Seriously,
effective,
if you want a solution.
it will make a news item, but that's all. Otherwise,
May I make a suggestion then, Your Lordship?
Yes.
Your Lordship may direct the government to hear my representation, deal with it and come back to Your Lordship. At least a time-bound manner. Let it be pending, Your Lordship.
But see, madam, this is SLU core policy.
I bow down. I am not disputing that.
Stakeholder consultation, experts to be appointed, body to be considered. Now, we are conscious of our monitoring powers.
May I just make one submission? I bow down. My only concern here is my learned friend here has actually undertaken the exercise of actually applying to all these private organizations. She has actually given applications and received information of her own friends, of ITR returns, of
You sent it on 21st March.
Lordships.
Give them some time. There is not a single issue. This is not one issue with them.
Yes, Your Lordship.
Give them some time. Let them consider. We will pass that order that expeditiously it will be considered not maybe within a period of 3 months or so. Let them come out. Otherwise, your writ will be opposed on the issue of maintainability.
I
Then
am not,
it
Lordship,
never
I am
get-
not, this is not adversarial at
pending
all. Yes.
for you, that's all.
I bow
This
down.
may actually resolve your genuine concern. You
Yes,
have made
Your
a very good representation between 61 to 80
Absolutely.
page numbers.
These guys have worked very hard and they
Yeah.
have actually come up with
Corrected data.
information which
Maybe
is
the authorities are not, their attention is not yet drawn to that.
Lordships.
It's a very good exercise you can do.
And would Your Lordship consider directing the union government to consider, but keep this pending, may not issue notice, keep it pending, because we would want to come back to Your
You
Lordship.
won't consider if the matter is pending.
We would want to, Your Lordship, come back to Your Lordships.
Actually, if they consider, get a fresh, if there is no, not addressed, you will get a fresh cross of.
We'll come back then, Your Lordship. We'll do that. That's what they're saying. They will consider representations in a time-bound fashion.
So, dispose of it.
Recent Article 32 has been filed in public interest, seeking court-monitored forensic audit and safeguards against unauthorized private access to stock ITR, Equivalent of Internet data used for employment verification. The petitioner has averred that an unregulated private employment gas verification ecosystem has emerged. Where some private entities for access where the private entities for access increase and
They don't deal with, you can come back here again.
sensitive employment and financial data. We said data corresponds to the report made by the Income Tax Department and Central Board of Directors, Taxes. The petitioner has referred to an instance highlighting that between April and April. But we will July 22, a broader private verification ecosystem. It shows that the private entities, including a Plexigo technologies, describing data fetching describing themselves as data fetching and verification capability, highlighting their data fetching and verification capabilities. In some instance, the petitioner's case is that there is an illegal, unauthorized misuse of the private data of the individual by these entities and thus sensitive statutory data is being accessed outside the protected governmental ecosystem. This unauthorized exercise is alleged to be violative Article 21 of the Constitution. It is also alleged that data collected for sovereign functions is being repurposed for private commercial streaming. Consequently, the petitioner has sought inter alia the following direction. That's why in this regard we find that the petitioner has solicited a very comprehensive presentation. Comprehensive representations dated so 21st March 2026 and 22nd April 2026 to the official respondents. Copies whereof have also been placed on the court. So since the issue involves policy intervention by an expert committee, on the recommendations of an expert committee, we dispose of the petition at this stage with the direction fee. The Union of India and other official respondents to consider the presentations by the petitioner and take necessary action as required to prevent misuse of data collected by respondent, collected by the data maintained by Income Tax Department and Central Board of Direct Taxes. In exercises there.
And if you are a conscious selling, you can deal with the government and other authorities.
Collected by the EPFO passbook API and Form 26AS API and take such necessary measures as may ensure that such data is not misused or unauthorizedly, is not unauthorizedly otherwise misused by the private entity. It will be appreciated if a comprehensive decision is taken and communicated to the petition, preferably within a period of 4.
I'm so grateful, Lordships, obliged. Deeply grateful. 4 minutes.
May I please, Your Lordship? 25th September 2025, the interim order was passed.
From time to time,
There
is pending.
matter is pending.
That's the petitioner authority initiated a tender process for development of a dedicated south container for at Pradeep Port on a build dash operate dash transfer basis through a public dash private partnership. Respondent 1 and 2 also agreed, but while this qualification notice dated 10 September 2025, their application was rejected and categorized as inverted commas non-qualified. The agreed private respondents have appealed to High Court of Odisha through petition number 26886 of 2025. The High Court passed a self-declaring interim order dated 25th September 2025 restraining the petitioner authorities from proceeding further on the basis of to proceed further pursuant to the tender process. Next paragraph. That order is now being challenged before us. Next paragraph. It is not in dispute that the matter is still pending before the High Court. What is the next date?
Next date is not coming, Your Lordship. Last it was listed on May. And that day it was not also taken up.
We are informed that last time the matter was taken up in May 2026. Next paragraph. Since finalization of tender has been stalled, we request the High Court to take up petition number 26886 of 2025 and decide the same at the earliest. This point. We can't direct the High Court anything, we can only request High Court.
Your Lordship, some time.
It doesn't look nice.
It says a national report as the container berth, Your Lordship, that only in this eastern region there is no container berth.
You produce this order, you have also taken more than a year now, almost.
To come here, 8 months delay.
Your Lordship, please, some time, Your Lordship.
It doesn't look nice for High Court that we tell that you
Preferably what, Your Lordship?
At the earliest we have used the word.
Preferably 4 weeks or something like
You
that.
have used the word at the earliest. Please go and submit it.
Your Lordship, this side or that side, Your Lordship has the deeply obliged.
Item 6, there is a
Deeply obliged.
Item 6. Letters and move by any day.
That's item 7.
Yes.
7, OBC. 7, my lordship, the connected matters coming up. Item 6. 7.
मुझे पता है जो सब there is a development after which I'm sorry.
My lords, as far as item 7 is concerned, your lordship's order where Mr. Mehta withdrew the petition says that the withdrawal shall not preclude any other affected person from approaching this court in accordance with law. So this court, now, my lords, the question still has to be decided whether when you include people with the Backward Classes Commission's recommendations, can you just withdraw the notification without the Backward Classes Commission's recommendations? Now, the High Court did a hands-off approach saying that this matter was pending before your lordships. Your lordships have subsequently disposed of the appeal at the request of the state of West Bengal, leaving it open for us to approach here. Now,
option now is that we request the High Court now decide the case on that.
Now, the development that that the solicitor was probably saying was the fact that the High Court has now, in another matter, not my matter, decided it.
No, I'm not. I was not going to say. I was saying to say some other development. But the High Court decided, a particular decision was taken by the High Court, which was before your lordships, which was withdrawn. After withdrawal, the government has issued a notification reverting the original.
This notification, in fact, is in terms of the High Court's first judgment.
First judgment. Your lordships are right. That can be challenged. I'm not
First judgment may be challenged, as well as the first judgment was in challenge at the behest of the state. the state having changed its policy since then.
My lord, I am not.
Just to withdraw.
But I am
Now,
not.
Parties may come and challenge that. Have any party challenged the
The
judgment?
subsequent withdrawal by the state government was challenged before the High Court subsequently. A judgment was passed and they have filed an SLP which is currently lying in defect. So that
Lord, I
that
will
is-
make it clear, I am not arguing
There is
that
no
this
point in
appeal.
going back, you mean to say.
Yes, there is no
Because
point
it is
in going back.
taken by the High Court and.
Yes.
Lord, I am not.
This has to come along with that.
This has to come along with that.
Ma'am, I'm your ladyship, I'm sorry. Lord, I'm not raising a contention that against the original judgment which was impugned in my SLP cannot be challenged. That's not my case. It can be, it has to be challenged only here. My lord, High Court cannot now take a re-look at it. I just wanted to say there is a subsequent factual development, that's all.
You mean to say the basis has gone, so if they have to challenge, then the old is now back, so therefore they may have to lay a fresh challenge if at all.
Well, what, my lord, I can't say what.
Number of that other.
That, yeah.
Then we
I've
list
just
both
passed it
cases.
on.
Well, list both, so and four cases.
Your lordship is posting this along with that.
Both cases together.
Both the cases together.
Very technically, you have to challenge the original.
We may have to file that also.
You stand exposed on res judicata.
No, even otherwise the basis would have gone.
With great respect, my lords, your lordship is right, but there is another way of looking at it.
You
That-
look at.
The subsequent withdrawal.
Use blinkered eyes to look at things.
No,
but
not
it's
in
better to
blinkered
look
eyes,
with open eyes.
lawyer's eyes.
What it stands today is what.
Your lordships opens both eyes and Shiva's third eye. That I'm entirely aware of. But the point is this, my lords, that even if they had to withdraw it.
It's your baby.
No, of course.
It is your.
But I'm sorry, my lord,
The more
only one
communication, the better it is
one
for-
clarification. Shiva used to open his third eye when Lord Shiva was angry. Lord, your lordship.
That of course. That of course.
So the simile, my lord, may not be true for this call.
No, but if we get into theology, my lords, Shiva's third eye, there were Mohinis also who could sort it out at times.
Yes, sir.
And-
Anyway,
They are all persuasions, and that is coming
Yes.
from the other end. Whenever intellectual and knowledgeable persuasions come from the bar, the third eye of the judge opens.
that's true.
Fine.
That's true.
No, they're tagging it obliged.
Policy remains changed today is what to get in.
Yes, the policy having been changed, but they can't do it without the backward. We will file another petition also, my lords, that.
Whatever.
Obliged.
Great.
Please, madam. Lordships, item 8 should preferably be taken up along with item 50, which is a batch of petitions relating to Myra homes.
Item 50 can be taken
So
up now
item 8
because
is the same.
item 8 is in fact, Leonard Amicus's report was pending in all these connected matters. I appear for Mahira Home Lord. We have filed our responses. We have given our plan how to complete these projects to the Honorable
Who is going to
Amicus.
trust you, Mr. Uda? The kind of, the credibility of this builder, who is going to trust you? Who is representing the home buyer?
I am representing the home
Item
buyers in item 8, my lord.
50.
Item 50.
In any case, my lord, the Amicus's report has to come. We will also have a look at it. We will make our submissions on the basis of whatever is the report, my lord.
There's no need of report, anything, you just give a factual note, Sujan.
We have made detailed submission pursuant to my lord's order that you give whatever proposal, whatever financial things you want to give, you give it to the learned Amicus, and Amicus submits the report like in all other builder cases. Amicus report has been submitted. My lord, then we also get to know that.
I've made a summary of the factual aspects
And
of
Lord,
this.
we
batch of
also get a
petitions.
copy, and my lord, grant us some time to go through these summaries, my lord, which have been prepared because.
This batch of petitions, your lordship.
Who is representing the home buyers in item 50?
My lord, I am in item 50.6 and item 8. For item 50, the main matter.
Of course, you have challenged with all allegations against this builder, we understand that.
My lord.
But what is the via media? What is the solution?
My lord, we are before your lordships, my lord. The learned amicus has prepared it.
Very fine, but we have to find out some viable solution.
Please, my lord.
You are not going to trust this builder.
My lord.
This
My lord.
project was launched which year?
I'm sorry, my lord.
This
These
project was
projects
this
were
was
of
in
2017 to 21.
And
Five
blood
different
supposed to be
projects.
complete.
They were supposed to be completed within 4 years.
somewhere,
of
my lord,
the
22,
completion-
23,
4 years of the
24.
approval of the building plan. The first building plan was approved in 2018, your lordships. So the expected date of, scheduled date of completion was 2022 in respect of the first project.
And my lord,
in
we
sector
will, my lord,
68.
grant us
that's
opportunity.
after
We
the
will
policy.
explain that why it could not be completed in 22 or 23.
Prayer and
So, my lord, today,
My lord.
So your prayer is to send it to MB.
my lord, in fact,
Lord, one of
we
the prayers-
volunteered. My lord, in
NBCC
fact,
or
we volunteered to say,
Trust you. You have already duped them. Your entire money has been siphoned
My
from these
God.
people. Who is going to trust a builder like this? The question is that if they have already taken your money,
My lord.
siphoned it somewhere else, how MBCC will complete?
My lord, NBCC has also given certain proposals. I'm sure the learned amicus Cure has also given some options in the learned amicus's report. That's something that we still have to consider.
You just examine this angle. How to make this project viable?
I'll do that.
Is there any, like, MBCC is probably a government of India entity.
NBCC is a public sector
Is
undertaking.
there any public sector entity who can also be?
There are some others, for instance, Engineers India Limited is also into kind of group
Engineer India Limited is
constructions.
also a credible name. And probably in Gurgaon side, they have done some projects.
Yes.
On the highway, when you go, I recollect one of the projects by them. I'm not sure about residential or commercial, but one of the projects is by them. So maybe that these, some government entities need to be, this is affordable scheme.
This is an affordable housing scheme of the Haryana. state.
affordable
These are
housing,
affordable housing schemes.
affordable housing scheme.
Affordable house, the state is creating all mess. Why, how they grant license like this and when they refuse to monitor everything? The rate is fixed by them, license is granted by them, the rate is, everything is done by them and then they suddenly disown. Now, only way out is that on what terms and conditions they will be
So,
willing to complete these projects. We can continue to have a court monitoring, whether it is MBCC agrees or any other government entity agrees. You please explore that part also.
I'll do that, sir.
And,
Lord, may I suggest one thing, my lord? In a bail application, one of the owners, my lord, the builder, ED had filed a reply. ED had come out with a solution. If the amicus can look into it, what is flowing from a lordship is probably has already been taken care of by the ED in that reply.
how
Yes.
it is going to
For
cost us?
reconstruction, I mean, the construction.
Yes, they have come out with a proposal, my lord, and that it can be released and it can
We
be
are
done.
concerned about, since when ED has
The amicus
started
can
constructing a
assist
part-
your lordships. I'm not saying, Lord, I'm for a home buyer, my lord. I'm for a home buyer. We need a plot, my lord. So amicus can, my lord, look
What was
into
the
that.
rate of allotment? What was the rate of allotment?
Rate?
My lord, in
4,000 rupees per
4,000.
square feet.
4,000.
That was a rate determined under the affordable housing scheme.
If
Currently,
amicus
the
can-
rate is 6,000 per square feet in Gurgaon.
If amicus can look into it, my lord.
Also, we are only telling you practical solution.
Please, Lord.
People also be reasonable.
We are always.
Suppose instead of 4,000, if you are agreeable to 6,000, which is the current rate,
We can always put to our.
that this additional amount will be create a corpus to the government entity to whom we can give the project. And let that government entity commence at least the projects with that additional, some financial, facility which will become available. For that you will contribute and under court monitoring that can be then utilized.
So first of all, we can have, sorry.
Meanwhile, you can also found out that ED can help you in that. If there are some assets of the builder,
Yes.
we can attach
Yes.
and get it auctioned through court proceeding.
Madam.
That money
I will assist. We will assist.
Humble submission, my lord, today is that the home buyers have invested their life savings, my lord. The home buyers have invested their life savings. Now, a lot of them are paying rent as well,
Even that money has been siphoned.
my lord.
What will happen?
We are
at a loss of.
We are on a road, virtually on a road, my lord.
He is in jail, we have already rejected his bail.
We are on
So
a
what
road,
will happen?
yes.
Unless the project, how to move the project?
Yes.
Eventually you need that dwelling unit.
Feasibility, my lord, feasibility.
And today, don't forget about the market forces and market condition today. That 4,000, 6,000.
It has gone to very high, sir.
It's gone up.
All of you know very well.
We know that, my lord. We know that.
20,000, 40,000, whatever it is.
My lord. My lord, there are certain solutions proposed by the NBCC also in a techno-economic feasibility report, which is also on record. And the learned amicus may have considered.
Lord Learned Amicus has given this report today. We will also will go through it. And we'll make our submission.
Notice, when the Micros will submit a report, then say these matters pertain to these petitions at the instance of the home buyers seek a direction to case number 7 in bracket Messrs. Mahira Infra Tech Private Limited, as well as to the authorities of state of Haryana to complete the housing project under the affordable housing policy of state of Haryana. The Mahira Homes Sector 68 project comprising how many total units, Mr. Jain?
5,292, sir.
5,292 residential units.
All the 5 projects, 42 towers.
All projects.
Sector 68 has 1497.
5 projects comprising 5 towers.
42 residential towers.
42
Lord, if I can take just 1 second, Lord, in between. Lord, what we had said was, out of the 5 projects, 2 we are in a position to complete. 3, whatever money has been received by us, we will return it with appropriate rate of interest fixed by this honorable court.
Who is going to accept? At that time, in 4,000 was available. Today, why don't we buy apartments for them at the place of their choice?
Because, my lord, the payments made. My lord, the payments made in the 3 projects.
Price or the market
I bow down,
rate has gone to 40,000.
Now, my lord,
they will gain out of interest.
My lord, the payment made is only 10 to 15% of this 4,000. The total payment made is 10 to 15% in the 3 projects. In the 2 projects where 70-80% payments have been received, we have given our proposal to complete these projects.
Were to commence in the year 2017-18, and the builder was obligated to complete and hand over possession by the end of year 2021. It is also undeniable that while 2 projects are, your last time report said that 2 projects are.
2 projects, one in 60 sector 68 and
103.
103. In sector 68, the completion is of a level of about 75%. In 103, it is less, but the builder has offered to complete these 2.
Those 2 projects we have offered to complete, my lord. Infusing our money and just recovering the balance.
Number?
Sector 68 and sector 103.
In sector 68 and sector 103, Gurgaon, have been completed up to 75%.
68 has been completed up to 75%. 103 is up to 15%.
Respectively. The petitioner dash homebuyers have alleged that entire amount of allotment price has been taken from them, and the respondent builder has siphoned the same somewhere else, leaving the projects incomplete.
Lord, that position we dispute, we have not siphoned off.
At this stage, the issue with which we are concerned is to explore the modalities for completion of the pending projects. The homebuyers have suggested that the Government of India entity, namely MBCC, may be requested to take over the projects, take over and complete the projects. Their learned senior counsel are agreeable for a fair enhancement in the allotment price so that the corpus can be created for roping in the new project for an entity like MBCC or any other builder come developer who might be inclined to complete the pending projects under the supervision of a committee that may be constituted by the court. We therefore request Mr. Rajiv General Micus Curie to contact MBCC or any other government entity, preferably government entity, who are willing to complete the pending projects. Let the terms and conditions on which the proposal is acceptable to them may also be ascertained so that home buyers can also be made to agree to such terms and conditions. And Micus may also look into the material on record, including the report set to have been submitted by the enforcement director to find out unencumbered assets of the builder in default. The appropriate direction in that regard shall be issued after a report is submitted by the landed Micus. Post this matter, meanwhile, the counsel for the home buyers will also have instructions. Post these matters for further consideration and so on so forth.
The state government also has a significant responsibility because it was their scheme under which the allottees had applied. And the state government also has the resources to a certain extent. They also have a public sector undertaking. If your lordships permit, we could direct the state government also to inquire into that.
We just forgot to mention that since the affordable housing policy has been evolved by the government of Haryana, state of Haryana, and the rate of allotment and beside and such scheme is implemented under the supervision of the state authority. We direct the state of Haryana also to explore as to whether the pending project can be completed by state agencies like the Housing Board Haryana or Haryana Shahri Vikas Pradhikar, HSVP. Unfortunately, no one has entered appear on behalf of the state. Today, we register directly to inform the standing council, who shall have instructions and remain present in court.
Also, kindly consider any such alternate developer would come in only once he knows how much inventory is available for him to sell and how much construction he has to do. So a claim verification process would be required, which can be undertaken by the DTCP of the state government. That is required because the builder may have cancelled several allotments while the allottees would be challenging that cancellation on different grounds. Or the builder may have sold off some inventories which are not there in the records. So consequently, one would need to know the amount of inventories available and to which the allottees claims are there and which have been sold or unsold.
The DTC, District Town and Country Planner, do they maintain any record regarding that?
Well, they have the
They have the powers because they have issued the license, and the license is under certain conditions to whom the builder can allot and what inventory the builder can sell. Consequently, the state government can seek that information from the builder and also then ascertain from the allottees whether that information is correct or not. For instance, your lordships, in some cases, I learned that the builder has cancelled the allotment on the ground that the allotment have not paid their due installments. Now, the installments were due on a time-linked plan as per the affordable housing scheme. However, the allottees say that since there was no construction going on, how could they pay? So they say that we were willing to pay so long as there is construction. The forensic report says that money was withdrawn from the escrow account without due certification of the auditor and engineer, even from that 70% amount which is to be utilized for construction. So consequently, the allottees feel shortchanged that they paid the money, but that much amount of construction was not there and their allotments were cancelled for no fault of theirs.
There were
There are
also
two
questions
schemes.
on
If I can,
allotment
Lord, I can
itself, my lord. If
put
I may, my lord.
my perspective. Lord, the payments are the construction linked or time linked. If, and in every license, my lord, the DTCP while granting license decides whether it is time linked or it is construction linked. Once it is time linked, it was the obligation of the home buyer to pay it.
All these misdeeds are committed by builders only in collision and connivance with the DTCP and all these authorities. Everybody knows that it's all collusion and connivance.
Those issues need to be decided by an authority established in law.
We can direct the town planner to remain present in court.
My lord.
And then probably you can apprise him.
My lord. They have the powers under Rule 19 to do that so moto as well, my lords.
So, deem it appropriate to direct the district town and country planner, Gurugram, to prepare an inventory with respect to all the allotments and submit a comprehensive report regarding the
Inventories available.
inventories available.
Unsold
My lord, the allotment made, the payment received as per the record, my lord, because my instructions are many of them have not paid even the initial allotment money, the 10%. So even that record need to be summoned, my lord, in all fairness. That's
My lord, in that case, there will be unsold inventories. Those inventories will be opened up. They may be utilized by a future builder.
To summon the builder's report and submit a report to this court. Also, after verification of the builder's report, prepare inventory after summoning the builder's records and submit a report to this court. Post on so. Then we have to grant 2 weeks time to the.
We'll do that, sir. The other excise need not wait for this claim verification.
Grateful, my lord. My lords are also issuing notice in item 8, my lord,
Then
because that's a fresh one.
start
I'm
with
grateful.
that.
Very grateful.
For 9, I appear for respond number 5.
May it please, your lordships. Lords, the High Court, with respect, got completely sidetracked by prayer 4 of the writ petition. Prayers 1, 2, and 3, which are the crucial prayers, which is that whether a title of community forest rights once vested by the district level committee and which becomes final under section 6 of the Forest Rights Act, whether the district level committee on the behest of a project proponent can unilaterally cancel the title. That was, please just see the prayers in the petition for a moment, lords. If my lord sees the petition and the prayers, your lordship will find at page 284. Petition begins at 253. Please come to page 284, my lords. A PDF would be 323, I think, if I'm not wrong. Oh, your lordships have the physical file. My lords have 284 minutes. Prayer A, prayer 1, in view of the facts and circumstances, set aside the order dated 8/1/2016 issued by respondent 4. This is the order cancelling the title to community forest rights unilaterally behind our backs without compliance with natural justice. Prayer 2, hold that the rights granted,
286, sorry, 285.
hold, I'm so sorry.
Hold the rights granted.
Hold that the rights granted under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act cannot be cancelled or revoked. Any other relief, that relief would be consequential on 1 and 2, which can be relief, maybe compensation, maybe a relocation of the rights, because under section 41 and 42 of the Right to Fair Compensation Act, these rights can even be relocated. They can be compensated in many different forms. Now, prayer 4 is what is the High Court has gone only on this, that now there's a stage 2 clearance. How can we now look at it, etc., etc. I've got a lot to say on that, but
Mr. Singh, we follow what you are saying.
yes. Now I want to show you lots of the grave errors, even with regard to
single judge does not ignore the rights. Single judge says that the rights have to be, and because the projects have proceeded from phase 1 to phase 2, the best way is to monetize the rights into a monetary compensation.
But the single judge says, right, community forest rights, if any. But my challenge,
that way,
no, I'm sorry. This he does not decide my primary challenge. Just see the order for a moment. Just see how the rights get vested. I just want two documents, Your Lordship may kindly see.
Rights were actually vested. 2013 order was void because of not following a particular procedure. They recall the order in
that power is not there. So please.
Issue was challenged before you, challenged by the writ petitioners, and there is no clear finding of the single judge of the division bench that you do not have community forest.
In fact, it amounts to a rejection of my claim completely.
Finding is, how do we work out if you have a community forest?
And the finding is that I have no locus. This is something amazing. I'm not something amazing that the Gram Sabha members.
Those are side shows. We ignored that.
Just see the provision. No, just see the title for a moment. Please see. Please see P11. I'm sorry, Mr. Sorry?
Dinesh Kumar Soni, which is another case.
No, Dinesh Kumar Soni.
Yes.
Your Lordships are referring to.
It's a similar matter which you.
No, that's an allotment issue. Allotment of the coal block.
No,
Dinesh Kumar issue is allotment of the coal block.
In fact, that is wrong. Those
Nothing to do with
matters have nothing to do with this. Now, we are not challenging the allocation of coal block, and we can't.
Concerns both taking away the land, encroachment, and allotting coal allocation in that very area. Both are challenged in this petition.
No, but Dinesh Kumar Soni is challenging that is a different coal block.
It is not challenged here.
No, in fact, that is a different coal block altogether. Parsa, which is under challenge. We are not in Parsa. We are in PEKB, that is Parsa East Ketan Basin. Basin. Parsa East Kanta block. Kanta Basin.
PEKB.
Yes, PEKB. It's a different block. Now let's just see the title for a moment at P11, Lords, at page 213, and your Lordship will see the English translation at 214. This is how the title certificate gets issued. Page 214. Now, this is after the Gram Sabha has approved it, and then it goes to the district level committee. This is the title certificate. Title to community forest rights at 214 in English. Now, name of holder of community forest rights, Ghatpara Gram Sabha. Then below that, your Lordship see nature of community rights. 31B, community rights in the form of Nistar, right to firewood. 31C, right of ownership, access to collect, use and dispose of minor forest produce. 31D, right of use for grazing. Then there are certain conditions. Now come overleaf 215. Names of the holders of community forest rights, all citizens of Ghatpara Gram Sabha. And then it's signed, we the undersigned hereby for and on behalf of Government of Chhattisgarh affix our signatures to confirm the forest rights as mentioned in the title above mentioned holders of community forest rights, Divisional Forest Officer, Assistant Commissioner Tribal Development and Collector Sarguja. This is a statutory committee, which is a quasi-judicial committee under Section 6. Their order under 6.6 is final. By statute, it's final. It can't be questioned. Now, the project proponent goes to them and says that I had a clearance for forest. I had a stage 1 clearance prior to this. How did you give this? So they write a letter, my lords, to them at page 241, written by the project proponent, not to anybody else. And at 245, my lords, the district level committee issues this order. Just at the behest of project proponent, no notice to the Gram Sabha, no compliance with any law, nothing.
But please see page
Now-
190.
Just
They
a
applied
minute.
in 2013.
I'm
That
sorry.
is the point out.
I'm sorry. After this,
190.
after the community forest rights are certificate is granted, there is no review of it. There's no power under the law to review it. And your lordships have held repeatedly that where a quasi-judicial authority passes any orders, where unless the statute expressly provides the power of review, right or wrong, the order can't be, it has to go to the higher level. They could have filed a writ petition or anything, but they could not have gone behind our backs and gone to them and said, withdraw your order. And he could not have withdrawn the order in this manner. This is the prayers 1, 2, and 3 were pertaining to this. Now the High Court says you have no locus. On what basis that the Forest Right Committee, we had the Gram Sabha had authorized the Forest Right President of Forest Right Committee because we wanted them to be petitioner number 1, along with the Hasdeo Arand Samiti, which is petitioner before your lordship. So they backed out finally, and that president of the Forest Right Committee said, I don't want to prosecute this petition. So in addition to the first petitioner before your lordship, 6 of the Gram Sabha members, with the authorization of 400 Gram Sabha members, applied to the High Court for impleadment. They were impleaded as petitioners number 2 by 1 till 2 by 6. Out of those, I have myself verified, Lord, the list, the original 437 applicants for community forest rights. 2 by 1 and 2 by 6 are themselves applicants who signed the original letter, which is at page page 184. The others are all the son or wife of the original applicant, and because a person may have passed away or something, or they were younger at that time. All 6 are members of the adult members of the Gram Sabha, in favor of whom the community title is given. So this is a complete abdication with respect on the first aspect. There are several judgments, Lords, where the High Courts have taken the view in respect of this, that there's no power of review. I have those orders with me, Lord, I can place those. In fact, Lord, interestingly, the learned single judge...
We need to examine whether there is a subsisting community forest right or not. We are not inclined to injunct the mining operations, but they are subject, if there is an underlying forest right available to the petitioners, to a monetary commitment. Now, the courts have glossed over this by saying there is no subsisting forest right indicated in paragraph 17 of the impugned order. Legality and correctness of that finding in
All right, Lord, individual rights have already been given to them. We have already paid compensation. They've gone. That's the reason they have withdrawn also. There is no community right which was there. Please see their application. That is important.
We need to examine that.
No, I have no issue. I have no issue. I'm only
because rightly, wrongly, there was a confirmation.
I have no issues.
Community forest.
I have no issues about that. Only one thing I'm pointing out.
Well, Learned appears for Rajasthan, Vidyut Nigam.
Not only one thing
Now,
I'm allotted the coal block, Rajasthan.
Yeah, but don't be unfair to tribals. You don't take away the rights of tribals.
Lord, please have a look at page 190.
Allocation for mining purposes is concerned, that issue stand closed in 2011-12. That we will not permit you to arrange it. But
no,
if you have the community rights or the forest rights, don't what is the modality of paying compensation?
No, it's not just compensation. I'm sorry.
This order in the address of Coal Block.
Please, Mr. Nadkarni, please. But let me just answer. Now, when a question falls from the court, my learned friend should not try to drown it out. I don't think that's fair. This is not how we argue matters in the Supreme Court. Let me just answer.
This order.
What are you handing across?
Question.
Let me answer. When a question falls from the court, I think in fairness, my learned friend should not try to drown it out. Look, so far as the community forest right is concerned, just hand me that map. Now, I'll show your lordships, the community forest right itself is not firstly entirely in the coal block. Part of it is outside the coal block, but it's been wiped out by one stroke of the pen by the district level committee on the project proponent's letter. Now, secondly, outside of the coal block, there are still contiguous forests. Under section 41 and 42 of the Right to Fair Compensation Act, even these forest rights are recognized, and there are different modalities for working them out, including shifting the rights of the tribals. And now just see that map. Just show the map. If your lordship just sees the map, well, they are separate pages. Give copies to the other
Please
side.
have a look at this order which I've
just. If your lordship just sees the map, which is.
Lord, please see the order which I've given.
Lord, just see the map with the forest.
And says projects will not be stopped.
One second.
Same community rights issue. Please see this.
I'm not on the project.
Please see this.
I'm not on the project. I'm sorry. Yes, just see this. The one titled map showing forest compartment boundaries. My lord, have that?
Same coal block, Lord.
Your lordship find that much?
Disposed of.
Now please see.
Disposed of.
Now,
No, Mangalsai is not disposed of.
Mr. Nadkarni, please, I don't understand this. Are you so anxious? Are you so anxious to defeat the tribal rights? You're a state government entity of Rajasthan.
After saying, my lord asked me a question, I'm answering.
No, you did not. You interrupted me. Now, would your lordship please see this map? My lord may just kindly grant me a moment. Please just see.
What you
Mangalsai is pending, Lord. Mangalsai, Parsa. That's right. Which is both together. This is Parsa, this is the other one. Same area.
Now, lords.
And in that matter, your lordships clarified, project will not be affected.
I'm not on the project. No, please just, would your lordship see the map titled Map Showing Forest Compartment Boundaries? Please take that for a moment, lords. Do your lordships have that, lords?
got it.
Yes. Now just see the green portion which has CFR title. The green portion.
You've given some other map.
Yeah, 3 maps are there.
No, not been given.
The one showing a title map showing forest compartment boundaries. There's a green portion which is on the right. It says CFR title with an arrow. Now that CFR title which is given.
An intersection which falls within the area you are.
There's a P2002 comes outside of the coal mining block. So it is not as if they could have wiped out our rights completely. Our CFR rights have to be, our community forest rights have to be preserved and protected. So what we are saying, lords, as far as prayers 1, 2, and 3 of the writ petition are concerned, the High Court has abdicated its duty. It has not decided those prayers at all. So far as prayer 4 is concerned, it's a matter of your lordship are dealing with that in another petition. There's some petition filed by another person. Your lordship is already seized of that. I'm not on that. But I'm only saying, please don't foreclose me today. Issue notice to them. Let them file the reply. But my right.
The order. The order.
We are issuing notice, Mr. Singh, but only on the issue of determination of the forest rights and the modalities to enforce that right.
For enforcement of those rights.
Modalities. What will be the modality?
Modalities for enforcement. Yes.
Lord, in that,
my lord may
just said it will not be affecting
may,
the
may I
project.
request your lordship may say that prayers 1, 2, and 3 of the petition, especially. Or,
SLP, we'll consider.
my lord.
Issue notice returnable to so and so date, to determine one, whether there exist community forest rights. 2, whether there exist individual forest rights. 3, if so, what is the modality, whether adequate compensation for
Or any other remedy.
Any other.
Shifting land or
41 and 42.
shifting of area.
You are saying compensation or any other
other
remedial
Measures.
measures.
Other remedial measures have been taken to protect and enforce such rights.
Correct.
To protect and enforce such rights. Then say, it is how clarified that tendency of these proceedings shall cause no impediment on the ongoing mining activity.
Mining, since 2013.
Ongoing mining activity.
Obliged, grateful to your Lord.
Lordship, with regard to respondent number 5, we can accept notice and waive the service.
Five, Lord, we are referring.
Service may be waived by the respondent.
Five,
R5, you are.
Yes, Rajasthan Raj Vidyut.
Rajasthan Raj Vidyut.
Anyone for state of Chhattisgarh also?
No.
Now main issue will be state versus them. States will have
But
to.
standing council can be notified.
Can serve as the.
We can serve standing council.
To serve the
A short returnable date may be considered.
Obliged.
Wait, please, my lords.
You, Mr. Goswami,
This
you submit this issue before that committee. Now we have notified, and that committee will examine this also.
grateful, my lord, grateful.
This court has wide open pursuant to constitute the high powered inquiry committee. That the issues raised in the instant of petition be also placed before the said committee for examination.
Yes, sir.
This was the.
Please, my lord.
Sadhu, what can we do now?
My lord, I know very well, my lord, there is very difficulties, but what's happened, your lord?
You disposed of your petition, directing that these issues will also be examined by that committee.
My lord, that's right. But permit us the affected journalists and concerned media organizations, if they choose so, to place their victim-specific material directly before the HPC, my lord.
You place the entire material there before the committee, the petitioner or the affected persons.
And my lord, kindly
entitled to place the entire material before the high-powered inquiry committee. We request the committee to consider and make necessary recommendations, stock report at the earliest.
My request is, my lord, kindly take this petition with 969 of 2026, my lord.
We have directed, that's why once the report will come, then we will issue a certain direction. और इसको उसके साथ ही रख दो, to the High Court, we are making some observations.
Your lordship kindly made an observation, I will apply, because your lordship, I have applied several times, but matter.
The petition may, if so advised, move an appropriate application for the High Court, making out a case for out of turn hearing. That such a prayer we consider by the High Court sympathetically.
Highly.
Section 11. This is 11.
Item 12.
My lord, this is a section application, 11 application. Notice, grateful, my lord.
This may have to be considered, I think. So,
Okay.
My lord, deeply disturbing amendments have been carried out in the 2014 Mizo marriage divorce and inheritance laws of Mizoram. My lord, it's a tribal state.
We appreciate that probably if when the amendment is quite on prima facie, at least it looks to be. But why have we not gone to High Court, please?
My lord, our difficulty is this. My lord, I asked the same question to the petitioner. My lord, it's a very small state. My lord, 11 persons per kilometer is the population density. My lord, the petitioner seems to be extremely sensitive towards the institutions of Mizoram. My lord, be it the legislature, be it the High Court. My lord, she's a working principal there. My lord, she runs a chain business where.
High Court is not in Mizoram.
No, my lord, we have an Aizawl bench. My lord, we have an Aizawl bench.
We asked the principal bench of Guwahati.
Yes, my lord. My lord, the difficulty is.
What is the purpose of establishing High Court? Why Constitution said that there shall be a High Court for every state?
I bow down, my lord.
This aggrieved lady is not required to come to Delhi. Her grievance could be effectively addressed in Guwahati itself. That is the purpose. Why she should, poor lady, spend on litigation for travel expenses, stay expenses in Delhi?
My lord.
She is entitled to. She has
Yes,
a
my lord.
grievance.
Yes, my lord.
We appreciate that.
Yes, my lord.
We will request the High Court to immediately take cognizance and decide in Guwahati. Don't go to Aizawl bench.
My lord, I bow down. My lord, I asked her about Guwahati also. My lord, she says since the 7 sister states are interconnected. My lord, she has 2 young children. My lord, she lives in a tribal area somewhere near Aizawl. My lord, she runs a school also. My lord, apart from a school, she has a business which has around 1.7 lakh females from Mizoram associated with her business. My lord, the difficult. Just stand there.
Petition the High Court, will request the High Court to provide you expeditious hearing. Don't burden this woman with so much litigation expenses that she is required to travel to Delhi for fighting this cause. He has a good cause, he must fight, and let the High Court take a cognizance of it.
My lords may give me one liberty. My lords, if there's a security issue for her even in Guwahati, then my lords, that would be, because my lord, she is extremely apprehensive with regard to filing in.
Apprehensive of what?
My lord, apprehensive of a backlash back there in Mizoram.
In backlash will be more in Delhi. It will come in the.
Very well, my lords, I leave it at that. My lords, I leave it at that. I leave it at that.
Take the benefit of one High Court
Yes, my
judgment
lord.
also.
Yes, my lord. I bow down, my lords. I bow down.
The amendment in the Mizo Marriage, Divorce and Inheritance of Property Act 2014 which has been carried out by the Mizoram Legislative Assembly. In our considered opinion, there is no necessity for the petitioner to approach this court directly, as her grievance can be effectively redressed by the jurisdictional high courts, by the jurisdictional high court. The petitioner's apprehension that the matter may not be heard at Aizawl bench in a charged atmosphere can also be effectively addressed by requesting Honorable Chief Justice of the Guwahati High Court to list the matter before principal bench at Guwahati, before his own bench, before his principal bench at Guwahati. Therefore, Next. Further. The issue raised on behalf of the petitioner prima facie requires preferential attention. However, we do not express any opinion on merits at this stage. The instant of petition is disposed of with liberty to the petitioner to approach the principal bench of the Guwahati High Court, where her petition may be entertained in light of the observations made herein above.
Heard by the Guwahati bench. By the
We have already said.
Very well, my lord. Separate. Grateful.
Disposed. Yes, item 14.
Yes.
Your Lordship, it's a Your Lordship, I was just requesting the blasting activity is still going on, Your Lordship.
Let us get the respondents who have come in.
Who is sponsoring the petitioner first of all?
Oblige, Your Lordship.
September 26, tagged with civil appeal number 8176.
What is this? And court has dismissed it, saying that you have to go to.
Yes, please.
My lords, the arguing counsel was supposed to join us through VC.
Is there.
Yes, Mr. Gyan Shekar.
May I please, Your Lordship?
Please.
May I please, Your Lordship?
Yes, Mr. Gyan.
But I am Jnanasekaran, Lord. I am the petitioner, Lord, in the appeal as well as Lord, the petitioner, Lord, in the writ petition filed before the Honorable High Court, Madras. But I have filed, Lord, the writ petition after making, Lord, representations on 20th of March and, Lord, 11th of June to the High Power Committee, disqualifying, Lord, a candidate, fourth respondent, on the ground, Lord, that she has violated the code of conduct by bringing in political influence. She belongs to a political party, namely Vidudhai Sirthikal Katchi in Tamil Nadu. She was sponsored by the political party. Complaint was given, Lord, to the High Power Committee.
Mr. Ganachekar, we have already constituted election tribunals. You file your election petition and challenge the election there. What's the question of entertaining a writ petition?
But at the time, Lord, when I approached the writ petition, the election was not conducted. My complaint was before the committee. Committee did not take any action. Therefore, Lord, I moved the High Court.
Committee will not, because election has been held. After the election is held, rightly or wrongly, only the election petition is maintainable. And for entertaining the election petition, we have already constituted election tribunals. So you approach the election tribunal, file an election petition there.
Yes, sir. Grateful.
The petitioner is approved by the election of respondent 4 to the Tamil Nadu State Bar Council. Since the election has already been held and result declared, liberty is granted to the petition to file an election petition before the election tribunals constituted by this court, by the order dated so passed in so. It is clarified that we have not expressed any opinion on that.
Grateful.
Because this is again one of those 79, 80-year-old people.
Similar matter.
Similar matter in pan.
December 2026.
And I'm maybe permitted to serve through the council, standing council, Millets. And I may be permitted to serve through the standing council.
Yes.
And Millets, and the amount be deposited before this honorable court with the rate of 12%.
Number 2 and 3 are directed to bring the entire amount payable to the petition by way of a demand draft. Entire amount along with interest by way of a demand draft.
Deeply obliged, Millets.
Item 17.
This is the Jharkhand matter. Lord, the students are protesting for last more than 1 month. The state government firstly, Lord, they cancelled
There are multiple examinations.
multiple exams, two examinations, Lord, mainly. One is Public Service Commission exam of the state, another is Staff Selection Commission exam. And now we want, Lord, one.
Out of anxiety, the judicial service exam is also conducted by the Public Service Commission or by the High Court separately?
No, by the Public Service Commission only.
We are more worried about that exam. What kind of?
So our prayer is either a CBI inquiry into the matter or an inquiry by a former judge of this honorable court.
A former judge, how can a former judge, because these are not inquiries, these are investigations basically. You have to summon report, you have to examine, sometimes you need a forensic report, sometimes you need.
My lord.
All these things can be done by.
That's why, Lord, the CBI inquiry the students are protesting for last, Lord.
The state.
High Court has a stayed. The state, one day, it was the same day, it was prepared, it was filed, it was mentioned, it was stayed. And the state also indirectly supported this.
Lordships, for state lordships, I'll receive the notice. Lordships. For the state, respond number 4.
Are you accepting notice?
Lordships.
For Jharkhand state?
For lordships. Respond number 4, lordships.
R4. Accept notice on behalf of state of Jharkhand. Number 4. You have instruction, the matter.
Lordships, I've been told to. Lordships, I was.
Give a show date.
Somebody else will appear for JPSC.
Lordships.
We'll have to go.
Yes.
Obliged.
Which PC is on pen?
Lordship, I am appearing in item number 18. A similar matter was recently decided. I am requesting for the same order.
We have passed that order.
I am grateful.
Wait, please.
Item 19.
For the caveat terminals. Act has been held to be unconstitutional on the ground that it violates 300A. The learned single judge may not consider it on the question of legislative competence, violations of.
Protection. Consider. We have to.
My lord,
I'll take notice, my lord.
That's right, my lord. Therefore, it was considered.
There you go,
on
ninth
the-
schedule route, MMDR was put in the ninth schedule.
MMDR is put in the 9th schedule.
So, look at MMDR is a mirror legislation to the legislation in 21 for minor minerals, what relates to major minerals. Now you put it in ninth schedule for MMDR. How can you 21 Kerala law be beyond ninth schedule without compensation?
There are two aspects, my lord, which were considered, or which was urged. One was, my lord, when it comes to 300A, there must be a public purpose, my lord, which is underlying the legislation in question. The second is regarding compensation. My lord, the one judgment which has gone into both these aspects in some great detail is KT Plantations. And KT Plantations, my lord, I have placed a judgment on record as well. My lord, if your lordship, what has happened in this case is this. No, my lord, the state was in three parts earlier: Travancore, Cochin, and the Malabar area. Insofar as Travancore and Cochin are concerned, my lord, Travancore and Cochin parts are concerned, there were proclamations, my lord, which were pre-constitutional, the legislations in question. It provided, my lord, for levy of royalty on subsoil mineral rights to be levied by the state, and it has been going on also. What happened, my lord, is that in a judgment called Thresiama Jacob, the full bench of the Kerala High Court, my lord, rejected a challenge on the ground that even for the private property, royalty cannot be levied, even if, but the challenge was on the ground that in private property, the mineral rights also vest in the private person, and therefore royalty cannot be levied. Full bench held otherwise, said that in so far as subsoil mineral rights and subsoil mineral rights, minor minerals are concerned, the other one is governed by MMDR. The state would still be entitled to levy royalty as such under the minor mineral concession rules, which are framed in the section 15 of the MMDR. No, my lord, the matter was taken up before this honorable court. This honorable court held that it can, these are either zamindari rights or janmam rights or whatever the manner in which it is called. My lord, there is a detailed discussion of the land tenure. But ultimately, it was held that there is a statutory vacuum insofar as the Malabar area is concerned, part of the erstwhile Madras presidency, and therefore, my lord, they are in a insofar as private properties are concerned, royalty cannot be levied on the subsoil mineral rights because there is no vesting of the subsoil mineral rights, my lord, in the state, insofar as private properties are concerned. This, my lord, Malabar area, this led to a situation, and this has been found as a fact by the learned single judge also, that there was complete lawlessness. In the sense, my lord, that they did not pay any royalty, my lord, insofar as the permissions are concerned under the MMDR and the state rules are concerned under the MMDR, framed under the MMDR, that no environmental clearance was necessary. Nothing was necessary. Therefore, there was complete lawlessness as such. Now, my lord, what we did, the legislative response, what we could do was to bring the Malabar area on a par with the law that was prevailing, my lord, under proclamations, pre-constitution proclamations, insofar as the Travancore and the Cochin area are concerned. Therefore, my lord, the act in question, the very short legislation said that the subsoil mineral rights would vest in the state, even insofar as private properties are concerned. Challenge was mounted on the ground of legislative competence inter alia, and, my lord, then violation of 300A as well. Learned single judge went into it in some great detail and upheld the legislation, and, my lord, set it aside only in relation to some demand for royalty which was made prior to 2019, which is the date on which the act is enforced. Though, my lord, it is passed in 21, there was an ordinance from 2019, and therefore from the date of the promulgation of the ordinance, my lord, the act is given force as such. Division bench, my lord, upholds the judgment of the learned single judge insofar as legislative competence is concerned, and said that it could either be 18 or 23 of list 2 or 43 of list 3. But when it came to the question of 300A, no, my lord, what we had contended was that please get into the substance, my lord, of the manner in which a 300-day challenge is considered, my lord, insofar as acquisition of property is concerned, in the KT plantations is concerned. My lord, it goes into a great detail. Now, if your lordships kindly come to paragraph.
Mr. Giri, at best you can argue that this is only a declaratory law of something which had already vested by way of eminent domain of the state. But that was never the argument for the state. The argument for the state was a statutory instrument to occupy a legislative void indicated in John. Now, if that Tresamma John holds, then the argument of eminent domain does not lie. That this is a declaratory law of something which was already owned by the state.
Tresamma Jacob, my lord, does not go against eminent domain.
No.
It doesn't go against eminent domain.
That the right, the subsoil rights have to vest in the state by operation of law.
This is the law.
Since the operation of law is a legislative vacuum in the Malabar area, whereas covered in respect of other portions of the state of Kerala, you cannot claim ownership just because you are taking royalty.
No.
In terms of the
we
provision.
did not say it that way. We said, please look at the Act. The Act contemplates a vesting. And suppose, my lord, it is competent for the legislature to declare that the subsoil mineral rights
There
vest.
is no doubt of legislative competence. It's
Yes.
a question of constitutional virus under
Infirmity insofar as 300 days concerned.
19
That's right.
of Constitution.
That's
where
correct. That's
the
correct.
state vests certain properties which were not its properties because of Tresamma John saying that these were properties of the Rayatvars of the area. It must have a just and reasonable
My
compensation.
lord, it is on that. It is on that, my lord, that the provision, twin provisions regarding.
Exceptionable logic.
Lord, I'll take your lordships to that. Lord, it requires.
Says there is
Lord, there is.
either you reenact and seek 9th schedule reservation.
Now, my lord, the problem, there is another problem which is crept about on account of, but that I'll take your lordship to that later. No, my lord, what has happened?
KT is noted, either nil or no compensation.
9th schedule reservation, my lord, we will require the assent to the president. But before that, my lord, could your lordship sit? My lord, there is a huge burden now cast on the state by reason of the direction for refund of royalty. But that is, my lord, I would pray for that only if your lordships are prepared to examine this, my lord. But please have a look at the act in the first instance. Sorry, the 367. But I'll just take about 5 minutes on the question of KT plantation.
Under the Act, you have been collecting royalty now.
Yes, my lord.
The High Court now says to refund it.
Yes.
Problem is, Mr. Giri, that is the whole problem, because unfortunately, it's not a declaration of any pre-existing right. It's only creation of right first time.
No, my lord, even, no, my lord, declaration of a pre-existing right, suppose it is upheld.
You would have understood that argument, but that argument is cut short because of the Supreme Court judgment.
Supreme Court will not destroy the Tresamma Jacob does not get into that. Tresamma Jacob simply says that in the Malabar area there is no law.
Tresamma Jacob predicates this finding that there is no law by saying that in absence of law, the consequence is that the subsoil minor minerals are of the landowner until and unless such land is held by a pattadar under the Estate Acquisition Act.
But that's only in relation, my lord, to the area where the Travancore and the Cochin proclamations were not valid.
We are saying.
And therefore, my lord, we have
public purpose, Mr. Giri, is well taken.
That's right.
The state had a public purpose to make the law.
That's right.
Now the question is that when the state has a public purpose to make a law and thereby vests certain properties, will it not be a part of the legislation to qualify the test of 14 and 19 to have some compensatory package?
That's right. That's right. This is the argument.
And if you have to circumvent this.
Not circumvent,
In the ninth.
not circumvent it, my lord.
I mean constitutional compliance.
You have to look into the.
Constitutional.
Lord, please have a look at the legislation which has been struck down. It's at page 368 onwards. My lord, it hits us very hard. And therefore, my lord, I would pray for a little time of your lordship's intelligence, my lord, to take your lordships to the
practical dynamics of the
how much they will not be practical dynamics, my lord, for a small state like Kerala. It hits them very hard.
Estimated burden is.
Estimate burden is about 1,000 crores. Estimate burden, I am told, my lord, this is my instruction. This is about 1,200 crores, my lord. He yesterday.
Cut it up now.
No, that's my lord, because he must have got updated instructions today morning. And therefore it happened. The direction for no, my lord, what now happens is, it is not as if the royalty is paid on two fronts. No. That argument is also, my lord, taken note of by the learned single judge, not upset by the division bench. Would your lordships kindly come to page 368 and 369? That's where he acted. Lord, on this question of compensation, before your lordships get into that in a moment, what really happens now is that land is left intact. If he doesn't win the mineral, then there is no levy of royalty.
Do you still have any contemplation for revisiting the legislation?
You can make.
We can.
Another law where you can adjust the royalty against compensation provision.
Yes. That's precisely what, my lord. That's precisely what.
Advise you on legislative.
No, my lord.
Policies.
My lord, I am not trying to take advantage of what fell from your lord.
Legal.
This is what I have. No, my lord. What happens is this. They should have made it clear. No, my lord. We don't win the minerals. We don't extract it. The state doesn't extract it. What the state does, my lord, is that there is a declaration that the subsoil mineral rights are vested in the state. No, my lord, when does a levy of royalty come? When he wins a mineral. What are they going to get this fingers? Sorry. What happens is this. Though there is a statutory declaration that the minerals, subsoil mineral rights vest in the state, we don't take it and sell it. The owner of the property, and that's what all of them were carrying on quarrying with gay abandon. They sell it, and when they sell it, beyond all this act contemplates is a levy of royalty on the quantity of mineral which they extract and they sell. Notwithstanding this, therefore, the compensation part comes in. All that it required was one sentence here saying that, therefore, they are entitled to do that. They are actually doing it.
Mr. Giri, it is like, suppose you tell the rubber plant owner that oh, like the 10% of your product will belong to state, or you tell your tea estates that 10% of your product will be of state. There is something like the same manner, it probably going by the legal position. The land belong to them, subsoil belong to them, mineral, if any, belong to them. On extraction, you are saying you will charge royalty.
No, not that, my lord. What we have stated is that in two parts of the state, or as it existed then, the subsoil mineral rights, my lord, statutory vesting is in the state. And there is a royalty levied on all minerals, my lord, which are extracted therefrom by the owner and selling it. The MMDR rights, the rules framed under the MMDR for minor minerals by the state comes into play, and there is a levy of royalty in only insofar as the licensing provisions are concerned.
Giri,
What we have done is,
Giri, that is why when you open the case, we told you MMDR is item 90 of 9th schedule. If you could have got that protection, easily your law survives.
no, my lord, that's what I'm saying. My lord, they only need have done that, but in practice, that is what is happening from 2019 onwards.
You can't give the blessing on 9th schedule to all
The vesting comes only in 2019.
Correct.
So after that?
No, but before that, my lord, it was complete lawlessness. Nobody required a license. Nobody asked for a license. Nobody paid a license fee in this part of the state, which was part of the Madras. My lord,
19 law. Mr. Datar, let us see that how they come out with a, what kind of amendment they are proposing in law.
Yes. But one more thing is very important. The judge has just touched upon it. It could be fatal to the
response to what fell from my lord, the Chief Justice. Any other activity in this land is not being protested by the state at all. For example, my lord, one part of it, they want to carry on a rubber plantation, let them do it. Many of them are doing it. What happens, my lord, and if they want to exploit commercially any portion of the property insofar as the minor minerals are concerned, they are permitted to do so. We are not standing in the way, notwithstanding the statutory declaration under this enactment that it vests in the state. Therefore, my lord, that is not being touched.
Once it is vested,
All that is, but I agree with what fell from your lordships. Shouldn't we have said that here?
Yes, you should have more.
I asked them.
You have sharp legal mind.
Lord, in my own-
in a state and
In my own humble way, Lord, I'll ask them to do that.
For this mining, are they not required to have any environmental clearance, any regular?
They were not having it, my lord. That's what the learned single judge said. They were not having
Lord,
it.
may I just say one thing, Lord? The Lordship's permission.
It is not required. It is required by them, but the learned single judge says that undisputedly, page number 481 para 61.
Deepak Kumar made his judgments of the Honorable Court saying that it cannot be contested without the proper this thing. And the argument is absolutely wrong, madam.
In what argument is wrong? I'm saying about the judgment of the learned single judge.
My Lord, I wanted to say just one thing, if your Lordship permits me.
Yes, Mr. Datar.
Yes, my Lord, my learned friend is partly wrong because in the Travancore Cochin law, which he says is different, there is a provision for compensation. In the Malabar law, there is no provision for compensation. Secondly, my Lord, my learned friend, if he's going to amend the law, today the law is fatal because of the second proviso to Article 31A, which says that if the lands are within the ceiling limits, you have to provide market compensation, and 31A applies to estate or any rights under that estate also. So that also they will have to take care of. They have to provide for compensation, and those lands which are within ceiling limit will have to be provided at market rate. That is the mandate of Article 31A of the Constitution, which has not been taken note of. And in Travancore Cochin, there is provision for compensation. In Malabar, they say no compensation. So serious amendment, maybe the land law has to be redone completely.
I'm sorry, because neither the learned single judge nor the division bench has referred to it in that way, and they said that those two proclamations
It has
have
to
a
be
provision.
reenacted completely.
Lord, I would
The council will be to. In which item you will be able to accept nothing?
Two SAPs.
One to accept no.
29034.
Six of.
And 29039. We are accepting it.
Meanwhile, the royalty amount as directed by the High Court is there. How the petitioner state will also not levy any royalty. It will also not levy and recover any royalties till further order.
Stay of refund.
Refund stay.
No stay.
Grateful.
But you can't also now recover for some.
We are only now for you to.
At least one place
Let them come
is
back.
saving the solution for the state.
Via media will have to be.
Only thing I wanted to point out, we should be like to get this from the government. Suppose even if we win, it's a Herculean task.
It's another proof.
And in fact, in case you ought to feel that is appropriate to direct them to whatever be so far the petitioners are concerned, let them deposit the amount.
It's a state, my lord. Why should?
No, because if it's a.
Why should they be worried about the solvency of the state?
We will see. Do they have money to deposit?
In fact, in fact, due to revenue recovery, people.
You must be aware of that civil suit the Kerala has filed.
The thing is, many people against them, they have started recovery right from, I mean, even much before 2019, and revenue recovery was initiated, and people are losing their properties. And of course, this is only with regards to recovery. But what I'm suggesting is, in case, some amount has to be deposited by them in the court, at least we'll get something out of them. Otherwise, it's very, very difficult.
No, we'll take care of that.
Great. That should be staying the recovery.
Yeah.
Great.
We have still recovery, we have also stopped them from levying because now the.
Yes.
Great.
Deeply obliged.
Deeply obliged.
Lordships have stayed the refund.
You not a direction. is
The other one, yes, of course.
You will not also recover it for us.
Of course. I don't think they'll be that foolish. But anyway, now that your lordships have passed an order.
One thing, your lordship may indicate that in the event ultimately refund is made, reasonable interest will have to be provided. If we are going to retain the money now, some reasonable interest has to be provided. Whatever your lordship will, 6%, 7%, whatever.
Mr. Datta, they will take out a law where compensation will be adjusted.
They'll pass a validation act, Lord.
Yes.
Deeply obliged.
Great.
Because I'm requesting for a passover on item.
For validation, I have.
Item 20, my lords, I'm requesting for a passover, my lords. I'm being led by the learned SG.
Passover. No passover today, on some other date then, after first.
Lord, item 21, my
31st.
item number 20.
In item 20, my lord.
And like the only argument is this page number 126 is the similar order. I'm only seeking that. That's all, man. Deeply obliged.
Would your lordships then consider having item 20 next week, my lords? There's some urgency, my lords. There's a issue.
It has said first week September.
31st or first?
Deeply good.
31st. 22.
Please.
Lordship, may I have it then on 31st?
Which one?
32.
Which one? Rajwala, yes. Yes, 32.
Your lordship may,
There is another matter.
There is another.
CSAM.
my lord, that is only on child's, my lord, I've gone through that matter.
My lord, I'm only, that is on measures, my lord, your lordship may should notice, as far as tagging is concerned, my lord, that is only on reporting by the intermediaries. My lord, that is one very small issue of this larger thing. My lord, we are looking at a reporting mechanism to the.
We are not saying anything, we are only saying it will be.
No, let it be heard. I'm not one. What happens that when the matter is tagged, unfortunately, my lord, then this whole thing gets submerged. This is a larger issue. And I'm not here. In fact, your lordship.
It gets submerged here.
My lord, I hope sometimes, my lord,
Entire ocean will submerge that small sea.
But my lord, what happens is the lead matter, my lord, it gets a little complicated. Your lord.
Problem that these are so serious issues.
It's extremely.
Consideration, deliberation, and the judicial forum is perhaps not equipped to go into this exercise. There are issues where there is a sense of legislative lethargy which we need to catalyze. But to take over this responsibility is perhaps biting too much.
My lord, I'm so grateful, my lord. I'm completely, but my lord, we had worked with the government for a significant period of time, and in fact. Right. Lord, would your lordship consider giving a returnable date? Right.
Returnable expeditious disposal.
Bail application.
Item 23 bail application. Though we are not inclined to entertain this written article.
We may file.
However, keeping the sections of the statute discussed, we request the High Court to take up any miscellaneous bail application number 1291 stroke 2026 and dispose of the same at the earliest.
But the problem is that there are two types of lists in Allahabad High Court. One is the fresh list and another is the additional cause list. And the number never reached that, my lord.
We just passed an order, considering this is a bail application, this will be taken up at the earliest.
That's what.
For us 24 and 25, I request for a passover. I'm led by Mr. Sibbal. I'm in both the matters. My lord, led by Mr. Sibbal. My lord, he's on his leg in notice. My lord, will take it over after lunch. My lord, that's simple.
For notice. Singly wants a notice. You will say no passover.
No, I didn't say I corrected my learned friend. I corrected my learned friend.
Just your lordships must see the prayer.
Anyway,
that's serving.
My lords may have it after lunch.
It's impossible.
Your lords will carry by Mr. Sibbal, my lord. No reason, nothing.
Notice.
Lords,
Will take up along with, though it is not connected.
only one side. Lords, they are different matters.
There is only one side.
So I will keep
They have stayed the investigation.
Yes, that is why we are giving notice. They're giving notice of that.
A short date it will come.
We can today issue notice only. We can't stay the order.
Then give a short date, very short. Short date. Because what has happened is, in the meanwhile, I'm not asking today, but in the meanwhile, I can't investigate. Forget the rest.
Dr. Singh, it runs contrary to our order staying arrest in another case.
Yes,
Because there we have said on condition of cooperation.
Absolutely.
I'm very grateful.
That matter is also listed today, but there are some letters.
Not to
We
arrest.
thought that at least this old bits dying hard in that state will now stop. But we are sorry to say that whosoever may come, the old habits.
You file bail, bail is pending, you go to 482, you get what you don't get.
Not 482,
226 constitutional validity challenge and stay of investigation.
All your judgment
There
in
are
America and all, I just
several
kept
modes of fighting political battles, but not like this.
That's fine.
Only an early returnable date.
Which is contrary to your lordship's judgment, Malas, the recent judgment of this court.
I'll show you, yes. It's contrary to many judgments. It's contrary to many judgments.
The impugned order is.
Impugned order is.
We are should notice.
Oh, very well.
Well, kindly give me a fixed date at least, actual date. Please give me a fixed.
Yes,
I'll be very grateful.
27th, of course, the High Court is hearing the matter, Malas, on 27th August.
High Court.
On 27th.
Because that
3 days later, the matter is being heard, Malas.
in that case, your lordship must allow the
They
investigation.
will take an adjournment there then, Malas.
Either they take an adjournment or your lordship allow the investigation.
This is all, Malas.
It's a very fertile area.
Yeah. Yes, sir.
Next time matter will be heard, there will be some another new round.
So give me an actual date, brother. Otherwise, this argument will be
Yes, sir.
very well.
My lord will give. Obliged, Malas.
That's 24 and 25. Yours is 24.
Malad, both 24 and 25.
Both 24 and 25, Malad.
Same petition.
Yes,
Yes.
Squash.
24 and 25. April.
And the other matter, Malad, the next 45, Malad, they have to file a reply.
45 is any reply 5 being filed.
They have not filed, Malad, not filed.
Letter, my lords, in item 50.
You need time?
Yes, my lords, we
And
need.
then state council seeks and granted 2 weeks.
My lords, 2 weeks.
2 weeks time to file the counter affidavit. Post on so date. Interim direction to continue.
Interim order to continue. Obliged. Malad.
Much.
On 46, the council had joined through VC.
What happened? Somebody is appearing?
He's appearing through VC.
Court master, somebody is appearing in 46, please show.
See the quantities, Malad.
Yes, yes. Yes, Mr. Mehta, argue. Unmute yourself.
Lord, this is prayer for anticipatory bail. Lord, I have been implicated upon the third person's disclosure state. So, Lord, first they registered an NCB crime number 8 on 15th of February. And on 15th of February itself, they raid my house. Whereas, Lord, the disclosure statement which they have recorded is of Jasbir Singh, who's the third person, which stands recorded on 16th. And then my name figures out. When I point this thing to the High Court, Lord, they take a U-turn. They say that no, in fact, the original accused from whom they had recovered the contraband. Lord, in fact, the main accused from whom they recover this contraband, Harpal Singh and Ranjot Singh, they are both let go of. The next day, they say that on 16th, we call them to our office. We get recorded their statement under 67, and then they name Jasbir Singh. On the same day, they say that Jasbir Singh stands arrested. He then names me. Whereas their Panchnama shows, and I have shown the CCTV footage, Lord, on 15th, they come to my residence. They ransack my entire residence. Lord, page number 67 to 71, I have the CCTV and the original footages which I have reproduced. Lord, on 15th, now Lord, my case for anticipatory becomes more stronger because they ransack my house, they do not find anything. Lord, they take away both my vehicles, they arrest my wife, they arrest my brother. My wife gets released when the High Court intervenes. But my brother stands implicated when they say that he is therefore harboring me. But Lord, even in my cars, there has been no recovery. Now, my Lord, surprisingly, the arbitrariness does not end here. My Lord, they visit after every 1 week, torture my family. My Lord, they recover nothing. And then, my Lord, even during the pendency of the bail petition, my Lord, the IO along with local police goes, and on video footage, my Lord, he says to the family members and the mother that we will implicate you as well as your son unless and until your lawyer stops arguing before the High Court. Not this threat, I brought it on record. Para 19, the High Court judge observes that this is minor heat of the moment. And my Lord eradicated that this should not happen again, but this was minor heat of the moment and words were uttered in the heat of moment. Lord, this actually goes to the core of the case. I am not the main accused, Lord. The main accused from whom recoveries were effectuated have no connection with me. High Court has adjudicated 2 crimes. Now, my Lord, I was briefing my lords on NCB crime number 8. But then, my Lord, surprisingly, despite raiding my house and saying that I am on run since 15th of February, they say that at my very residence, I met another accused who has been arrested in NCB crime number 14. And I, along with rest of the companions, sat in my residence and we conspired again that on 6th of March, there has to be a fresh consignment. And on the basis of this, I now stand implicated in NCB crime number 14. Now, my Lord, surprisingly, where the lacuna arises, on paper do not name me. Lord, they present him again on 13th. The remand paper does not name me. Lord, on 16th, surprisingly, I am being named in NCB crime number 14 also. They say that while arresting NCB crime number 14 main accused, there were certain calls which have been exchanged with me, disregarding the fact that he's my neighbor. And I have brought land from him, which is a rasta, which is a way, which is a path towards my fields. And I have acknowledged that even before the competent authority. The competent authority evaluates my 10 years bank statement and finds not even a single penny of proceeds of crime. They release my property. They release this person's property as well. Now, my lord, the question which the court has considered is on two aspects. One, that there can be rigors of section 37 which can come into place. And the second one is Lord Samarth Kumar's judgment in which the anticipated bail was denied. But my lord, I have in my petition distinguished that both these conditions will not be met because in my case, my lord, there has been no recovery. I am the person whose house has been raided. I have given my request that I am willing to participate in the investigation. At least allow me to give my evidence. I am till date ready, my lord. I am ready to give my passport, my mobile phone, all my electronics have already been in their possession. They have taken away. My lord, what I am seeking is that I am only seeking one indulgence from this court, that at least allow me to join investigation. I should be at least heard once by the investigating agency who has been prosecuting me. And my lord, the second limb to it which has been going along is that my mother, my family members, my two small children have been repeatedly approaching the High Court that they have been torturing us. My lord, in this contingency, custodial interrogation is not warranted. The recoveries, whichever they have effectuated, is from person with whom they have not been able to produce any proof whatsoever. Even before the High Court, 31 pages long High Court order, my lord, their reply does not contain a single piece of evidence. My lord, whether corroboratory or substantiative, they have not produced a single evidence. No call details, no, my lord, my interaction with them, no financial transactions with them, my lord, nothing, my lord. And they are the persons who have been initially arrested and recoveries have been effectuated. I am the person who has been named in the third person's disclosure statement.
No case to grant bail.
Your lordships are examining this question, my lord. We have already vacated. The question is, my lord, where can the compensation, damages or mean profit, whatever name we may give, can be decided by the district collector. My lord, this is the order, my lord.
Point out. I don't want to interrupt.
Yeah, I'll come to it.
And computing excess paragraph.
Para 5 and 6 issue notice returnable subject to payment of areas of lease amount, if any, to the respondents within 4 weeks. Computation of damages as directed by the High Court shall remain stayed. Meanwhile, no coercive steps shall be taken against the officers of Petitioner Corporation on account of delay in the acquisition process. However, that's not here, not present. Because here that is paid. Now, there is one more order, your lordships. I don't wish to duplicate, but there are 3-4 matters pending from the same state with regard to the same ONGC acquisition.
There are subsequently also there were some matters.
Yes, my lord. One thing I must point out, my lord, it is sought to be, my lord, distinguished. Which this was placed before the High Court. That now the High Court, the Supreme Court is examining. Please do not pass this order. Lord, this is how the High Court is pleased to distinguish. Lord, page 34 of the order, my lord. The submission is at page 33, page 52. I'm not reading, my lord, submission. I'll just read one para, rest I'll not read. Before proceeding to issue any direction, we may note at this juncture the vehement submission of learned senior counsel for the ONGC based on the order of the apex court dated so and so. The said SLP was filed against the judgment of so and so. The distinction is, my lord, next page, my lord, para 55. Your lordships, my lord. Dealing with the said submission, we may record that the issues being decided by us herein are for the period of illegal occupation of the land in question. Same issue, my lord, you are pending before your lordships. After the notice to quit sent by the landowner lessors was served upon the ONGC in a monthly tenancy, which has automatically been determined at the end of month, that is 31st of August 2019. This issue has neither arisen in special CA nor has been determined with a judgment dated so and so. As the issue before us is different and distinct from issue determined under the judgment and order dated so and so, we are afraid to appreciate the argument of the learned senior counsel for ONGC asking us to desist from passing any order for fresh determination of rent, taking into account the annual rent value. Well, therefore, direction, page 57. We therefore direct Collector District Ahmedabad to authorize a competent officer of his office to determine the monthly rent, etc. But this is the question, whether this can be done by a district collector. According to us, there is no statutory power. It has to be done, by a civil court, which is being examined by your lordships. This distinction is without any difference, with my respectful submission.
No, my lord, this, after many years, my lord, this was 2006 lease, which was temporarily acquired for 3 years, my lords. Temporary acquisition, never returned back, the acquisition was never completed. Ultimately, in 2019, we requested that please vacate the land.
What happened to acquisition process?
We are not acquiring. We have retained, we have given the land back to them. We have returned them. We have vacated and returned them. We don't want to acquire.
The question is that occupation between the termination and the day on which you have returned the land.
No, there is no termination also. We have been paying the lease rent throughout. They say you quit it or acquire it. We quit, saying that we don't wish to acquire. Now the question is, for the damages according to them which is caused because of our continuance, and who will be the authority who will adjudicate the quantum of damages, collector or the civil court?
According to you, who will adjudicate?
The civil court, my lords. That's my case, my lord, in all these cases. Collector has no jurisdiction.
Consider the rate is maintainable.
Terms of this order?
No, my lord, no, not taken. My lord, the reason is this, my lord, legal reason. The question as to whether we were in illegal occupation or not will have to be determined because we were under a lease. We were.
That has been determined. Then we have to go into the question preceding the issue that you are raising.
Then, my lord,
first thing, see, what is the reasoning of the division bench? The reasoning is, this is not a registered lease reserving an yearly rent. If it was a lease reserving an yearly rent, then there is no question of illegal occupation, market rate, mean profit compensation. It could have been only a termination in terms of section 111 of the
transfer of property.
Yeah. Now, that 111 of the Transfer of Property Act has not taken place because you have been regularly paying the rent. Whether the escalation of rent was as per your discretion or it should have been on consultation, these are not really breaches which would amount to a determination of a lease which has no, which is not determinable otherwise apart from breach of the terms. So that issue they have decided, saying it's not a registered instrument, so it would be treated to be a lease with a monthly rent.
That is also in challenge before your lordships.
That is what we're saying.
That adjudication is also on challenge.
Beside that question, whether the interpretation of the document.
Yes, whether that
was right.
Civil court, how many years it will take in determination?
So already this is the third round.
That can be, my lord, an equitable consideration. I am only on law. And in all matters, my lord, your lordships were persuaded to issue notice and injunct the collector on this ground.
If we dispose of all the matters, subject to both sides agreeing, we can appoint some mediator there, some respectable, some retired district judge or someone can be appointed as mediator to determine.
I can take it.
Collector is also some government bureaucrat. He will make a hue and cry that they don't know how to determine. So a retired district judge, can be the mediator to determine.
I can take it, sir. So falling from your lordship's, my lord, without applying mine, my lord, I think.
Please, my lord, so many years have passed, we finally got some relief, my lord, after so many years. And it 2 rounds of litigation before the High Court, then the Supreme Court, undertaking to vacate, undertaking to acquire, not complied with.
You are entitled to certain amounts. The question is only of determination.
That's right.
Going to civil court means years and years.
That's right.
Collectors also, they are busy with multiple administrative responsibilities. They don't get time to adjudication this kind of. If some retired district judge.
I bow down.
Mr. Solicitor, you can also suggest 1 or 2 names. You can also.
Let me take instructions, my lord, or persuade, my lord, ask my clients. But only thing, my lord, High Court is still monitoring the matter, my lord. High Court may not, my lord, now further persist with the matter. And the collector may not start computing.
Instead of going into an adversarial situation, please mediate.
Bow down, my lord, I bow down.
Solution, because
yes, sir.
The only point I am highlighting, after many years we have got.
we understand.
Issue notice, then say, to accept notice on behalf of the contesting respondents number 1 to 14, then say during the course of hearing, we have suggested the parties in the instant case as well as the cases which are coming before this court, that the amount of compensation, that the right to seek compensation and the consequential amount of such compensation may be determined.
Compensation is for land acquisition also, where we are acquiring.
May be determined by a mediator who can be a former district judge. Then counsel for the parties seek and are granted time to have instructions and also suggest the names of the retired district judges.
Great.
Post the matter on so and so date. After 2-3 weeks.
Would your lordships, High Court may not, my lord.
And why further proceeding? Since we are proposing to refer the matter for mediation, further proceeding before the High Court are stayed.
Some fixed date may be given. The matter is fixed before the High Court today, my lords. If it is fixed today.
We have asked it because we are sending to mediation, therefore we.
Some fixed date here, your lordship making. That's all.
Will come after 3 weeks.
Yes, item 48.
Lordship, already 90% demolition has been done.
Why are you coming to us?
To the High Court again.
But Lordship, High Court is not considering these facts.
We have already, once we have interviewed, that does not mean that on every smaller issue we will come to the.
May kindly grant me intervention.
No case to interfere with the impugn order made out dismissed. Item 26.
Yes,
Just a minute, your matter is ready.
Item 49.
No, this is,
Just a minute. Wait for your rights. Item 49.
This is the one page, Amalas.
No.
That is different.
You're sharing.
49.
You're sharing.
We don't have the note.
They are just submitting it to the court.
Just give me. Let me give you. Malads, may I just place it, Malads? Malads, there are 3 aspects. First is the energy. So if your lordship will see, Malads, point number 1, energy arrears. This is para so-and-so of the note of the learned Attorney General. 13,066 million units mentioned therein does not account for 1.2 lakh units supplied per day to Himachal, and which finds mention at para 6 in minutes of meeting of so-and-so, annexed with the Union of India's affidavit dated so-and-so at page so-and-so. It is clearly recorded therein that energy is being supplied from Bhakra Nangal project to the consumers mentioned therein as mandated by Bhakra Nangal agreements and decisions taken by BBMB from time to time. Himachal Pradesh is mentioned at serial number 3 thereof.
After adjustment of 1.2 lakh units per day, the units due to Himachal stand reduced to 11094, that is 13,066 minus 1972. This, Millards, the judgment says in para 41, you have to adjust what has been given. Now, point 2, Millards, the cost which they have 3.77 crores, that's as per the note. Correct figure is 1611 as on 31/10/11 and 6368 as on 31/3/26. Details of interest paid, etc., set out in affidavit. Now, I'm not pressing this. I'm not pressing this, Millards. I'm just stating it as a fact. Now, this, Millards, the capital, that's why it's in brackets, Millards. The capital cost of 420.77 crores or 4,207 million has been divided by a rate of 385 per unit to arrive at 1093 million unit as per the note. Consequently, 13,066 minus 1093 million units is equal to 11,973 million units are stated to be due to Himachal as per the note of the learned attorney. It is submitted that this conversion should be on the basis of the O&M rate, that is the rate at which all states have been and continue to receive power from BBMB. Average O&M rate from 67 to 2011 for 3 projects was 11 paise. Current O&M rate is 79 paise. Normally, if we divide 4207 million, the figure which the learned attorney mentions, by 79 paise, it comes to 5326. Therefore, based on the current rates, the units due will be 11094 minus this. T1 of the note. The note of the learned attorney general suggests that the units mentioned therein be given over 15 years. However, the affidavit of the Union of India, that was 2013, and the written submissions of the learned attorney general dated 24/8/2020, Mr. Venugopal, in para 13 suggested a period of 30 years for energy disbursement. This period may accordingly be increased, from 15 to 30 years. These are the 3 things. I leave it to your lordship, The first is absolutely fact. The second, wherever your lordship feels, it should fit. And the third, this O&M rate is what we've paid throughout, and they are paying. In the past, since since the time the units were being supplied, and even today, that is the rate.
Mr. Attorney, this period of 15 years is consistent.
15 years already passed. Therefore, 15 years. That's why I said.
There are so many compromises made by us. No interest, no nothing. All these years, what have we been paid?
Last but not
Why
least,
should we have waited for 15 years?
Himachal is obviously doing much better than Punjab. Himachal is represented by my learned friend. They have Punjab has to make do with me.
To be Punjab.
Obviously, they're doing much better.
I suppose
they can afford him. Punjab has to make do with me.
In all my exchanges with all the officers.
This submission.
That's what I was going to suggest. I had almost more than a year or 2 of interactions with all the officers at the highest level and the ministerial level. So, and of course, this Himachal versus Punjab being financially richer, all that, of course, to discuss at great length. I thought ultimately, if this is the final solution, where a cashless solution, which will probably accommodate a large factor, we have arrived at that. Union of India has no the say on that, beyond that. And as I said, BBMB has gone into great at length the calculation to be relevant for the purpose. So I don't think you've got anything more to say beyond my note. Himachal has serious reservations on Punjab's questions.
Well, we will examine this one.
My lords.
In fact, my note captures all the... Yes.
Well, he's gone through, I think, 15 rounds of negotiations.
On
the basis of all the objections of Punjab.
Mr. Kapil wants to say that there's a distilled essence the Attorney General was able to produce for your lot.
And we were also asked, look, make concessions. We agreed to all that. Now you can't be reopening all this.
When question of settlement comes, then give and take has to be there.
Yes. Anyway, therefore, ultimately a decree should be passed so we can have it executed. That's all.
These are all factual figures I've given. These are not, and I leave it to your lordship. Having said that, my instructions are we leave it to you.
There are lots of facts that
all these facts
wherever
your lordship.
30 years, I think, is a wrong calculation. It must be 15 years.
No, even in 2020, Mr. Venugopal said, let it be 30 from now. I'm just saying that.
I mean,
but I leave it to your lordship. Whether 15 or 18 or 20 or 25, I leave it to your lordship. I'm just paying.
Yes, I can't say that. Pass the order. It's not right. You consider, you can't say that.
Please.
Obliged, man.
Very well.
It is an election petition, my lord, we lost in the High Court. My lords were pleased to direct us to deposit 5 lakhs, my lords. My lord, which we have deposited. My lord, to issue notice to the respondent, my lords, your lords directed me to deposit 5 lakhs, my lord, deposit, which we have done. So, my lord, notice may go to the respondent. Notice may go to the respondent, my lord, winning end.
Because we have deposited money, but it should notice now.
That was to consider whether notice can be issued or not.
It's an appeal. It's an appeal, my lord, there is no, your lords may kindly see, as per the judgment of this honorable court, my lord, since it is an appeal,
Yeah. Because my
the 2005 6 SCC page 81. My lord, when your lordships, initially your lordship kindly recall, my lord, I relied on this 2005 6 SCC page 81. My lords. No.
You get back 5 lakhs.
No, your lords may kindly see.
The other eventuality listen and then take the call. If notice is issued and then we dismiss, you don't get back anything. You lose both.
No, let me lose it, my lord. Let me lose it. I'm confident of succeeding.
Not do anything in the meantime, Mr. Term will, what is term will basic?
My lord, your lordship, my lord, I refer to 2005 6 SCC page 81, my lord, paragraph 16. Only after getting convinced, my lord, by the judgment, you will also pleased to say that we will issue notice provided you deposit this amount. We deposited.
Okay.
No case to interfere with the implement order is made out, especially the civil appeal is also dismissed. Or the amount was 5 lakh deposited by the petitioner with the registry.
Let's.
As it is reported with 16th May 2025, may be refunded without any interest.
Let's. May no, let's. Only 1 second, you may kindly permit me to say this, Mulats.
Yes, Mr. Augusto.
Mulats, I could not hear, Mulats, your lordship is dismissing it, Mulats.
We have dismissed the.
No, Mulats, in which case I will argue. Mulats, I will argue on merits, Mulats.
This is what we were saying that you argue.
Mulats, I will argue on merits. You may kindly see. You may kindly consider. But my case is, Mulats, that there was a criminal case pending against him, which has to be informed, Mulats, in the affidavit file. Failure to disclose the same amount of corrupt practice, and therefore on that ground, Mulats, the election can be set aside is our ground.
Now, synergy in the election field fight, you are good politician both.
But in a criminal case, there was a closure report. Then
No, closure report was filed, but it was not accepted by the court. But we are contesting, we have filed, it is still pending, till today it is pending, it has not been accepted. If closure report.
One thing, the requirement of law is a pending criminal case.
Yes.
When a closure report is filed, the criminal case goes into suspended animation until and unless the protest petition is accepted and directions are given either for further investigation or to file a complaint and cognizance is taken on the private complaint.
May I respond to this?
The closure report itself is not accepted and a cognizance is.
May I respond to this? Lord, may kindly permit me to respond to this. There was a closure report filed. Notice has been issued to us until it is accepted.
Nagabutu, it's not a question of what is the legal impact of the closure report.
Yes.
Vis-a-vis the continuation of the criminal proceedings.
Yes.
It is a question of bona fide disclosure by a contesting candidate.
It is not, law does not require. It is not closure by the police. Closure by the court.
Correct.
Until it is accepted by the court, it is pending.
We have no dispute over the interpretation that you are giving to the police report, praying for closure. But what we say is, if a candidate does not disclose a case on the ground that the police has prayed for closure, will it be said to be a dishonest suppression of fact.
Yes, it is suppression, but I got judgment to that effect. But it is suppression.
Understand the collateral proceedings independent of the criminal proceeding.
But it is suppression, but it will
Consider it from an employer-employee relationship.
But
Pending criminal case, there is a closure. The person says there is no pending criminal case.
may I submit, Murad? Murad, I have filed a compilation. Murad, it will take some time also for me to elaborate, Murad. I got a case. You will also kindly even have it tomorrow. I will elaborately argue, then you will, but it's a very sensitive matter. Murad, I filed a compilation also. Murad, there it has been, Murad, my humble submission would be, Murad. Murad, so if earlier, Rule 26, Murad said that if only in a case where cognizance has been taken and charges have been framed, Murad, it is to be disclosed. Now, Murad, after the judgment of this honorable court, rule has been amended. Now, as per the amended rule, FIR number with the name and address of the police station concerned used to be mentioned, but the FIR is still pending. So, therefore, there is an arguable case for me.
We can't ignore that you want to, by raising these hyper-technicalities, you want to defeat a elected candidate. He has won the election against you, and now you are creating all a kind of sorts of.
Murad, your Lordship, kindly recall, Murad, in the recent judgment, Murad, of Honorable Justice Mishra. Murad, where Murad, that Meenakshi Natarajan's nomination was rejected.
Yes.
Similar facts. Therefore, my humble submission, I will refer to everything, Murad. I will refer to the law. I will make a detailed argument. Will Lordship kindly have it any day subject to my Lord's convenience, Murad, NMD.
What do you mean by written arguments? Every time this kind of arguments being based.
No, I will argue. Otherwise, Murad, you please allow me to take your Lordship. Otherwise, your Lordship may kindly be pleased to permit me to take your Lordship through the judgments, the compilation, which I have not done. Your Lordship may kindly permit me. Murad, I will take your Lordship through the compilation. I will make out a case, Murad, that it is a suppression by him, and therefore it vitiates the election. It is a corrupt practice. I will explain. Then your Lordship may kindly, Murad, your Lordships are summarily dismissing the appeal, which is, in my humble submission, Murad, with great respect, Murad, it is against the judgment of this honorable court in 2005, 80, page 81. Murad, when at the first instance, Murad, when the matter came up, when my Lord was pleased to make an observation that the matter deserved to be dismissed at the threshold, Murad, I cited this judgment. Only after going through the judgment, my Lord was pleased to issue notice, pleased to say that.
To give us the judgment which you want us to go through, we will go through definitely.
But on the compilation. For a 16 minute, page 11, running page 11 minutes.
Yes.
It is thus clear that the upper courts, including the High Court, do not have power to dismiss an appeal summarily. Do have power to dismiss an appeal summarily. Such power is inherent in appellate jurisdiction. The power to dismiss summarily is available to be exercised in regard to first appellate appeals subject to the caution that such power will be exercised by way of exception, and if only the first appellate court is convinced that the appeal is so worthless, raising no arguable question of fact or of law, as it would be a sheer wastage of time and money for the respondent being called upon to appear, and would also be an exercise in futility for the court. The first appellate court, exercising power to dismiss the appeal summarily, ought to pass a speaking order, making it precise that it did not go into the pleas of fact and or law sought to be urged before it, and upon deliberating upon them, found them to be devoid of any merit or substance, and giving brief reasons. This is necessary to satisfy any superior jurisdiction whom the aggrieved appellant may approach, that the power to summarily dismiss the appeal was exercised judicially and conceivably by way of consciously by way of an exception. Now, Murad, in this case, Murad, I will argue, Murad, as to how, Murad, there are arguable points. Murad, your Lordship may have to give a detailed judgment. Murad, your Lordship may incidentally come to the next judgment, Murad. Murad, 2015 3 SEC 467. It starts at page 94. at page 145, 145.
Yes.
Minutes. Paragraph 82 minutes, last 6 lines. It is apt to note, minutes, your lordship has it in. Paragraph 82 minutes, last 6 lines. It is apt.
To note here that when an FIR is filed.
Yes, madam. It is apt to note here that when an FIR is filed, a person filing a nomination paper may not be aware of the lodgement of the FIR, but when cognizance is taken or charge is framed, he is definitely aware of the said situation. It is within his special knowledge. If the offences are not disclosed in entirety, the the electorate remain in total darkness about such information. It can be stated with certitude that this can definitely be called antecedents for the limited purpose, that is disclosure of information to be chosen as a representative to an elected body. Then
94.
Paragraph 94 minutes in the same judgment, page 151, 94.4. As a candidate has a special knowledge of the pending case, where cognizance has been taken or charges have been framed, and there is a non-disclosure on his part, it would amount to undue influence, and therefore the election used to be declared null and void.
The answer is in the paragraph in which you are reading.
Yes, yes. In our case, the FIR pending against him is very well known to him. Before the Honorable High Court in the earlier proceeding, he said that I will disclose everything in the election petition, I will face it. That order. After this judgment, the rule was amended, the form was amended. After this judgment, earlier, cognizance should have been taken, charges should have been framed earlier. Now, after this judgment, the rule was amended. You have to kindly see the original rule and the present rule. The present rule says that mere FIR is to be mentioned. The original rule, before this amendment was,
Yes.
the original rule was the following cases are pending against me in which charges have been framed by the court. This was the original requirement. If only charges have been framed, no, the matter used to be informed in the affidavit. Old form and new form, both are there.
Threshold is cognizance.
No, threshold is knowledge.
No, not knowledge. Threshold is knowledge.
Knowledge of what?
Knowledge that there is investigation going on. There is a case.
Of a criminal case where cognizance has been taken.
No. That was the original position. That was the original position before the amendment.
Original position was framing of charge.
Original position was taking cognizance.
No, sir.
No, it is there. You will not kindly see the original. Original position was?
Original rule was framing of charge.
Yes.
After PUCL judgment, as you rightly say, rule amended.
Yes.
FIR of such cases where cognizance is given.
No, it is not like that.
Well, that is like that.
You kindly have a look at it.
Like that, if you read,
with great respect.
Read Roman 4 of PUCL.
With
Roman
great respect.
4 of PUCL, the two questions of your compilation.
With great
Page
respect.
86. Page 86, paragraph 115.
This judgment, after this judgment, my lords.
This is the sheet anchor judgment.
No, it was, amendment was independent after getting clue from the judgment.
Read the amendment. Amendment is more
you will
clear.
kindly see the amendment.
Amendment says starting point is cognizance.
Amendment, may I read the amendment?
Yes.
The following criminal cases are pending against me, that is all.
Correct.
Other things have been removed. Other things, charges framed, cognizance taken, all have been removed now. Only criminal case is pending. That is the amended rule. Now, when the case is pending,
when a case is
column
pending,
table says,
when a case gets pending in a court by registration of FIR,
not pending in
or by taking cognizance.
Kindly see, it is not pending in court, has been removed. Pending in court was the original provision. Now pending in court has been removed.
Position was framing of charge.
Framing of charge, kindly see, now rule is Your Lordship, kindly see. The following criminal cases are pending against me. That is all. What is the case pending? It says FIR number with the name and address of police station concerned.
Very good.
That is enough.
No,
This,
sir.
here he
Read it
says.
disjunctively. No, don't read it disjunctively. See the other clauses.
I will read that. I will read that. Table. First, FIR number with the name and address of police station concerned. It is a first requirement. Second requirement, independent requirement. Case number with the name of the court. I am saying this. If this is to be, if case is pending, if already cognizance has been taken,
Not agreeable to this.
if cognizance has been taken already, that is to mention in column 2. Otherwise, it is to be said no. That is all. Then, section.
One argument we are accepting that instead of dismissing or appeal, we will pass a detailed order, but then don't expect refund of the amount. Now that we will impose that cost also. We'll pass a detailed order. Thank you very much for enlightening us.
Item 27 was
Your
that.
Lordship, kindly, because the law be settled, Your Lordship, kindly give a law. Your Lordship, please to give a detailed judgment. Let the law be settled. There be no confusion in future.
Give a detailed order.
But for having Milord's help, the law to be settled, should I lose 5 lakhs? Your Lordship, kindly consider. Your Lordship, kindly settle. In future, there will be no argument if Your Lordships are going to hold today. Near FIR need not be mentioned.
You donate it to indigent litigants who will be helped not only by the settlement of this law, but financially will find
I can't say anything.
You can't say anything.
I can't say anything except plead for return of the money, as instructed to me by my counsel.
Let us do like this. We're dismissing this SLP. You get back your money. It is return the money.
No. My lords.
Short order with refund. Long order with no refund.
Get back now.
Tell us what is to be done.
My lords, we are interested in the law being settled. We are interested in law being settled by your lordships. Let there not be any confusion in future.
Order is
Law is
dismissal.
already clear, but if you want us to reiterate that law, we will do that also. We are saying law to our mind is very clear.
After the amendment, there is no judgment. After the amendment, there is no judgment.
But the legal position, we are very clear in our mind.
After the amendment, there is no judgment. Therefore, your lordship kindly settle the law. With reference to the amendment. After the amendment, what is the position?
Sometimes don't raise the argument only because the junior is insisting for certain things.
And he said, I'm getting some instruction.
No, you do one thing. You will take the next matter meanwhile. You go and consult them and then tell us. You have given us written submission. If you want, we will give a detailed judgment also. But then we will not refund the cost because then you must bear the. After you are taxing the court time.
At times we are greedy. At times we were greedy, Millards, in expecting both to happen. We are greedy to law being settled and also for return of money. We are greedy. At times.
Both things will not happen.
I will, Millards, I may take instruction and ask them to report to the grateful.
So this is that matter concerning. So this is that matter concerning district judges from High Court of Karnataka.
Yes.
So Lordship Raj asked them. I have two submissions to make this, and I am usually and usually I don't make such submissions. Your Lordship sir asked the Karnataka High Court to come out with a solution. They have now, without even issuance of notice, filed a counter affidavit without even issuance of notice, without giving any options. We filed 3 options or 4 options, say how it can be balanced. The Karnataka High Court has filed a counter affidavit without even issuance of notice.
Never in collusion with anyone.
Most importantly, the person who has signed the affidavit on behalf of the Karnataka High Court is a party responded in person. This should not be countenanced. This behavior should not be countenanced.
I think this is something that is unfortunate.
This is unfortunate.
Parmeshwar is taking.
No, I'm not taking anything. It's an high court. A high court files an affidavit through a person who's a party responded in person. And he makes allegations saying that we have suppressed material and distorted facts. This should not be taken lightly. Your lordship told them.
You should also be aware, I think you must have represented some high court. It's not that an officer of the high court will draft a written statement, it is filed.
No, but
that's a system.
I understand, but to take, when your lordship asked
system, there must be a committee of judges who must have examined everything. Officer is only because he is a authorized officer, therefore he has signed it.
No, but he's party.
Don't take it like that.
No, he's party. He's a party respondent in this. He's interested individually in the outcome of this petition.
The Registrar General.
It can be anybody, but all
I think, in fairness, my lord had suggested that the matter is
sort it out.
Matter should be resolved. We have given options, various options, where there is only 2 persons, if at all, will be affected. All the others have either retired or have become High Court judges. These options should be considered by the High Court and the matter can be resolved, rather than taking an adversarial stand and making allegations about suppression.
We have been expecting that both sides will not take it as an adversarial litigation.
Yes.
So you are presenting.
Yes, I was representing the High Court, my lord. Apropos to what Mr. Parmeshwar said, my lord, there is no question of taking an adversarial position because there are officers at the end of the day, my lord. And this was only placed on record to demonstrate, and this will help in Lord finding a solution to demonstrate, according to the High Court, my lord, there was no excess appointment beyond quota, only that. Now, we may be right, we may be wrong, your lordship will determine if there is no solution. But I must also place on record only one thing, my lord, and your lordship would recollect that in 2014, when the 2008 direct recruits for the first time challenged, her ladyship as she then was, put a quietus to the matter in a particular manner, my lord, that judgment became final. So whatever was the cadre strength according to us,
the matter.
Okay.
Don't interrupt.
Whatever was the cadre strength, my lord, we've taken it from there, no one is disputing. So what your lordships were required to see is, because the ratio changed, my lord, because of the judgment of All India Judges Association. In 2005, it was 50, 25, 25. In 2010, it became 65, 10. Now it's again reverted back, and therefore, because of this back and forth, earlier it was 2/3 1. So what I was suggesting, as Mr. Vaidyanathan said, and Mr. Parmeshwar also, they've also filed on 21st minutes what they think it should be the seniority list. We can go back, sit together, and solve it. I'm not going to get up here because these are our officers and say, no, if something can be given to someone, surely he won't come in the way, my lord. So your lordship may actually, my lord, it will help. Your lordship may fix some date because there is some kind of this, why should I call him, we are colleagues, that kind of thing. Your lordship fix a date.
Meanwhile, you yourself examine.
Yes.
And what can be the modality?
Yes.
And what possible can be
very well.
Maybe that their grievances also you can independently look into.
Yes.
And
we'll see. So would your lordship just fix a date because I'll ask the officers
after 2 weeks
and our side to meet and then some date, and maybe the justice's intervention over there will also help.
While this exercise is being done, one subsequent development will have to be factored in by all concerned, which is the 3 respondents I represent have since been elevated.
So you have said we have no grievance against them.
I'm just
we have no grievance against
I know
them.
that the High Court is aware of it.
Right.
That is
Just pointed out.
Last time also we said, those who have retired and those who have been elevated, there's no question of pressing this litigation. There's no question of pressing this litigation.
Although the principle is the same, but it's good that they're giving up on those who have been elevated. At least.
In their objection to the provisional list, their stand was that limited departmental competitive examination persons are in excess. But in the writ petition, not a single LDC was made a party. Therefore, my lords, and their say was, it will have a cascading effect. In a post-based quota, the question of cascading effect would not arise.
We are not hearing it on merit today. We are only trying to explore that Mr. Rajiv Shabdar himself has been this side also.
Yes.
He knows better than us. And now on this side, let him examine independently and revert back to us that if need be, then we will adjudicate it.
Very well. We have given 4 options, Vilas. We have put it on paper. We have drawn up the list according to all 4 options. We have given it to them. We have put it on paper also.
I'll call Mr. Parmeshwar. We work together and I know Mr. Parmeshwar.
What they say is,
he's sitting with me.
Post will go out of
The
the
committee.
tender. Therefore, all 32 promoters will have to be pushed down.
But there is a finding. There is a finding against them.
65% of 32 may be affected.
Our suggestion will be that they have given 4 options. You have a right to disagree with those, but you can give your own options also, that these are the actual options available, and let both sides' options may be considered.
In fact, my lords, while arguing before the full bench of the High Court, I specifically filed a chart also appearing for the promoters that they agree that excess appointments have been made under LDCA quota. But unfortunately, no prayer is sought against them. No LDC is made a party. Therefore, this is a futile writ petition, and High Court would not issue a writ against persons who are not parties before it.
This is all merits of the matter. I don't know why they are getting this now.
Point very well taken, but we want to take it to a different level, where the High Court, as an independent, partial arbiter, would sit with the 3 categories and sources of promotees, ordinary promotee, LDC, and the direct recruits, and try to work out a solution which possibly to the satisfaction, if not to the satisfaction, to the maximum accommodation for everyone.
Not to the entire satisfaction, to some satisfaction.
Accommodation of every aspiration.
BT Kanzur, we are going back.
We are right now, we are exploring that part. We don't want officers to be litigation unnecessarily. You please give your options and your suggestions also. Consider those and come back to us.
Heartburn.
Yes, every court.
In this garden.
Your lordship knows.
See to it that
Yeah, I'll call Mr. Parmeshwar, Mr. Vaidyanathan, and all. We can sit together and do it. I have no problems.
But we have filed a draft, Lord, seniority list of 4 modes. Lord, any one of the modes, Lord, can be solved, Lord.
All right. Yes, sir.
Perhaps seniority list may not help, but reasons may help. That why
Yes,
any
Lord.
exploited or why a promoter or a director should be placed.
We have done that also.
Given 4 options.
4 options.
We have done that also. We have done that also. Even the reason we have
Sir, give your option, which according to you, like maybe maintenance of the list itself.
Anyway, I will tell before the committee.
But 3 judge
Don't
bench
want to
has-
tell anything now.
3 judge.
Here.
Your question of LDC not being heard may be addressed as a post decisional hearing before
But
that.
no LDC is recruited during their time.
In
No
the-
LDC is promoted.
Their
That is
objections
what
against the
kindly see the
provisional
draft
list, that was
seniority
their
list.
contention.
No, but no LDC is recruited at a time. We have produced that also, along with the draft seniority list. Yes,
First, Mr. Shabdar may consider, then we.
Yes, your lordship may have it after 4 weeks or so.
All right, after 4 weeks on Wednesday.
Very well. Great.
Item 28. Yes, Mr. Nath.
Regarding section.
I thought that you are going back to fight the election.
Money may be returned, it may be dismissed.
First order. Again, persuasive power of Mr. Nagamurthy is prevailing.
But outside the court.
Outside, he has been persuaded. Now
That's what I said.
Great.
Item 28, we will.
But this concerns theft of large.
We'll take up after that matter.
Yes. So your lordship might tag it with the.
No, Malaj. This is. Wake the question, Malaj.
Yes.
He cannot seek a direction for an FIR to be lodged. How can he seek? This petition is not maintainable.
Definitely.
That's why we have not issued any notice.
Yes, exactly, my lord.
So, my lord, in the other PILs, which also concern KG Basin block, your
In any
lordship
case,
has put it on 27th of October.
This matter can
this
cause
is independent of
matter. We are already.
Exactly, exactly.
Independent of those.
Yes, your lordship may have it
Notice,
after
notice
that
to be
day.
issued.
Obliged.
Yeah, no?
Item 29, there is a letter. Item 30.
The 30 is the de-notification of the, it might take some time.
Maharaj, my application on this has not been listed, Maharaj. We wanted to withdraw but that's
That-
not listed. So
that we are opposing, Maharaj.
item 30, Maharaj.
That may be
State
listed.
of Karnataka has filed an IA, Maharaj, which is not listed, unfortunately,
There are some
which is
applications.
IA number 209844 of 2024.
Yes.
So when the matter is listed, this IA be listed along with it. That's all.
IA number, the registry directly list IA number 7474 along with this case.
IA number? No, 209.
We can list then this matter on some other date.
Yes, Maharaj.
Just one submission, Lord. GAIL has sought and filed an implead application that may be allowed, Lord. Yeah, Lord, GAIL has
No, no,
filed
no.
implead
Maharaj,
application.
we have objections to all that.
24,
Maharaj. We have
9.
objections to all that.
That may also be listed, my lord.
We will hear then all the applications.
Yes,
Exactly.
Any date may be given.
That's okay.
I filed three IAs in the same matter. Those may also be taken up with this.
All pending
I'll give those numbers in right. I'll give those.
Any other IA? Meanwhile, we listed along with the main case on so and so date.
Nothing much to do.
Item 32.
आइटम 30 में ये आएगी लिस्ट करने के लिए ट्रिपल साहब ने
Get along with the what?
Lord, I'm seeking a pass home. My senior is on his legs before another court.
Another date. We didn't agree, no?
32.
We can discuss on the same day along with the same day separate.
No, 32. I am in 34.
Subject applicant. One application which is.
Yeah, yes, sir. We'll.
Because last order said that from the for Odro 8 May 26. Charge sheets have been filed and several.
Your options are on 30.
33 will not be. Investigation.
33.
Was ongoing. And then you said, we said a status report will be.
This is 32 or 33, Maharaj?
33.
Oh, I see. Okay.
Oh, 32 is so.
32, your chips.
All the others will be listed together.
32, Mr. Simple, there was another petition on a 30,
Oh,
Article
I see.
32, covering the same. So we have posted it on.
Obliged. Yes, yes, yeah, I know. I'm aware of it.
33, my lord. They were to file fresh status report.
Lord, we have the status report, my lord. We can, my lord, hand it over your lordships. May like to, my lord, examine it.
And my lord, they
This
they
is
should
by the
also,
enforcement
they should also
directorate.
file the charge
Only a
sheet
minute. Only a
before
minute.
your lordship, whatever charge sheets they filed, because two things need to be seen. Whether they have examined the role of the top management of these companies.
Mr. Bhushan, only a minute. Give me a minute. My lord, this is for ED and this is for CBI.
Your lordship may go through these to see whether they have examined the role of the top management of these companies.
Well, that's top management is only one person, right?
So we have examined top management.
He's only concerned with one.
Through these reports
Yes,
and then
yes.
take a call.
Yes,
Fair enough.
There are two status reports, one by the CBI, one by CBI and other by ED.
Enforcement director.
One by CBI and another.
One by ED, my lord.
The enforcement directorate have been filed in court. The same are taken on record. Post the case on so and so date for further consideration. For further consideration.
Please, sir.
Next one is non-miscellaneous date, this is Wednesday, Thursday, or occasion. I am applying. The reports are, the residence will be.
Lord, an item. Later.
Item 34, there is a letter.
There is a letter.
Item 35.
My lords, pursuant to my lord's last order, Mr. Anand Grover, my lords, he had filed that implement application. He is also on record, my lords. My lords had given him the liberty. And the next date, my lords, before the Kerala High Court is the 3rd, and the Honorable High Court has given a strict indication that that will be the date for final hearing.
Decided or pending?
My lords. On the 3rd of September, please, my lords.
The judgment is over.
Yes, my lords.
So I think better we wait for the judgment.
My lords can very well wait, my lords.
I moved an implement. We are informed that in terms of para 3 of order dated 17 July 2026, the Kerala High Court heard the matter.
It is fixed for hearing.
Also, fixed for hearing. Okay. That the High Court has commenced hearing. Then say post on so and so date.
Which would not
Await the outcome of those proceedings. Now, there is an application by who has been for the medical professional.
Implement.
There is application by Dr. Biju.
I'm appearing for her. But she's in a similar position where again, she requires a particular drug that is only manufactured as of now in the US.
Let we will allow you to assist us as an intervener.
Great.
I guess once is allowed to permitting the applicant to assist the court as an intervener. Post the matter on so and so date.
Item 36 is an interesting question of law interplay between
Yes.
IP insolvency court and
Whether the personal
And
guarantors
negotiable
get the benefit of the court. These are batch of petitions and conflicting.
Moratorium will apply.
yes, according to us, negotiable instruments act proceedings are quasi-criminal in nature and therefore may not. It will continue. That's our.
My lords, I'm appearing for 36.5. There's an issue of law that we'd like to also get addressed. Liberty to file an additional affidavit to 36.5.
My lord, 36.10 minutes, because my difficulty is.
Post the matter for hearing on so and so date. The parties, liberty is granted to the parties to file their additional affidavits, so complete the pleadings.
In 36. May I make a request?
I'm in 36.1. I'm for the respondent. My lord's wide order dated 9th March 26 had directed that the proceedings will continue. However, the petitioner number 2 in 36.1 has obtained stay from the High Court. My lords may have the.
He said, continue, no.
36.1.
I'm in 36.1.
Because in fact,
My lords, I'm for the respondent. However,
Go and approve the High Court and get a vacation.
lords, but in contempt of this honorable court, they have obtained the stay.
How do we know that in contempt?
Lords,
If there is a disclosure of order and on a different point, the High Court has granted stay.
my lords, because they have stated that, my lords, that's why I want to show this order.
Go and help the High Court to get this order corrected. Get the order vacated.
My lords, because they have made a statement that they are not the full-time director, whereas they have not made
So
any
that
such.
issue is not pending here. That's not pending here. That's a different ground on which the High Court is granting.
However, they have taken plea before this honorable.
My lords, in 36.12, my lords, they have concealed that they have filed a similar writ in the High Court and that's stand dismissed, my lords, and they have not even mentioned an iota about it.
Please on record, please don't keep the documents with you. We are granting liberty to the parties to complete pleadings to place on record additional affidavit. So if the document is in your hand, you will not be able to see. Whatever you want.
Minister, in 36.10, Minister, just one indulgence.
Liberty to file counter. Everyone is permitted.
They got a.
Meanwhile, the parties will file their counter affidavits, spoke additional affidavit, and complete the pleading.
Grateful, my lords.
Minutes 36. Minutes 36.1 is me. I don't know. We have no instructions that somebody else we have approached to the High Court.
Them come up with their counter, right? we will know.
Will be filed, we will come to know, then you only use.
Madam, my only prayer in 36.1 was no coercive action because the trial in Ludhiana court has been on.
The order is there, the order persists, right?
The order is there.
It continues, my lord.
My lord,
Continues.
the order got modified later on that subject and the proceedings will
Yes, the
go on.
proceedings will
I am
continue.
appealing one.
Final order will not.
No coercive action till the judgment.
My lord, what is happening is the Ludhiana court is putting up the
My lord,
matter
in
every third day.
36.1, my lord, I am
Very good. We
appealing, my
want the
lord.
petitions to
For
be recorded.
respondent number
Don't
9,
say
my
that
lord.
we are unhappy about that.
My lord, my only concern was the.
My lord, I have even withdrawn the complaint, my lord, that is being filed by the petitioner,
We
my
are
lord.
trying to,
Your lordship,
we have
in
appeared, everything is done. The only
36.1,
concern.
Get convicted, then we'll set aside the conviction.
My lords have
In
protected us.
36.1, my lord.
No coercive action.
In
Subject to
36
judgment.
Conviction is not a coercive action.
Absolutely.
Sending you to jail is a coercive.
Coercive action.
Your lordship, in
Absolutely.
36.
There was a confusion whether filing of a charge sheet is a coercive action. Somebody did file a petition
Yes.
that this is contempt, and the default bail provision was kicking in.
Yes.
Because they also don't deposit the money is ordered by the trial court. That's also a difficulty. The 10%, 12%, they say no coercive, so we won't deposit. That's happening in 36.10.
But in 36.1, my lord,
Obliged.
I am
Obliged.
for respondent number 9, my
Please,
my
because
lord.
matter has to be
My lord, I have withdrawn the complaint petition, my lord, which I
appear for
filed
the
before the court, my lord.
respondent, my lords.
I have even annexed the copy of the order, my lord.
Since it has to be a court-appointed arbitrator, I would only suggest the name of Honorable Justice K. Kannan.
Kannan.
Kannan he wants.
Justice Kannan.
Yes, Honorable Retired Justice K. Kannan of the Madras High Court and the Punjab.
Justice R.K. Jain.
The case is from Tamil Nadu.
Kannan.
Or Honorable Justice R.K. Jain, or any
For that, my lords, subject with utmost.
In the name that he is.
Please, Mullahs, because this is an Australian entity, let it be
Yes,
any,
they are an
any
Australian
party,
entity.
Mullahs, let it be before DIAC, if lordship.
So, my lords, this
My lord,
party,
in
the respondents are based in
36.1,
Coimbatore.
let
There
it come
may
and
be
record,
some
my lord,
language
that I
issues
have
also. Of course,
withdrawn
it's
the
an international
complaint,
commercial arbitration. If at all my lords are agreeable and the other side is also agreeable, for Honorable
What's the
Justice,
seat? Seat for arbitration.
it has.
It says in India.
It's domestic only.
Yes,
It's in
domestic.
India.
So,
India.
let it be Madras.
Mullahs,
Madras.
One party.
Mullahs, one
You
party.
are from Australia. Madras is nearer than Delhi.
Mullahs, we both are before the Supreme Court. So, Mullahs, let it be here in Delhi. My humble submission would be let it be here in Delhi.
Madras is not.
No, Mullahs, because this is with respect to export, Mullahs, export and import. So, Mullahs, my humble submission, if it is before Delhi, Mullahs, I can only beg it.
I only submit, my lords, there is some dispute. Of course, the dispute cannot be gone into by this court. Only to that extent, I say it will tend to the general convenience of the parties. They may be very permitted to join online also. The company is based out of Coimbatore in Tamil Nadu.
What is the difficulty if somebody is appointed in Delhi?
So, my lords, the thing is, even I am not conversant in the language in Tamil. Let it be there, my lords. If there are any practical difficulties also, it may be taken very well care of there than here. Let the ball be out of our courts and let it go there. It's in the party's best interest is what I say.
There's no question of any local language being involved. It's export of vanilla beans
All right, we will appoint someone.
from Australia.
My lordships may take into consideration the name suggested by us, by both the sides.
Grateful, Your Lordship.
Grateful, my lords.
My lords, I'm appearing for the petitioner.
Also after notice.
After notice, ladies.
Service is complete.
Service complete. I believe appearance has been entered by the respondent.
You are
Yes, Lords.
Counter affidavit also.
Yes, my lords,
Yes,
I
Lordship.
appear for the respondent. I need to make a very short submission, my lords. My lord, in this, when the notice invoking arbitration was issued, it was issued in the name of a non-signatory, my lords. My lord, I'll just request my lords to come at page 16.
These are all issues to be gone into by the arbitrators.
But my lord, non-signatory invoking arbitration goes to the root of the matter at the pre-reference stage is my submission, my lords.
Fox and Kings and all these things, sometimes non-signatory also can be.
My lord, I just one para, my lords, if my lords would want to see, my lords. Sir, just one para, my lords. After that, I'll leave it to my lords. And my lord, it's why this MOU new incoming partner has been inducted, my lords, and there's a no separate partnership deed also. So entire thing goes, my lords. MOU says, I'll just request my lords to come to.
What is it?
Para 33, my lords. Internal page 7 to 9, para 33. Can I read, my lords? Para 33.
What is the relation between the non-signatory and the signatory?
But they're husband and wife.
They have a commonality of interest.
But my lords, no commercial interest has been established, my lords. In this, I can include all my relatives in an agreement, my lords, who was not the party, my lords. But I'll just read para 33, my lords. 33 and 34. In fact, ASF Buildtech expressly notices the holding in para 169 of Cox and Kings, to what my lords referred, that the referral court was required to prima facie rule on the existence of an arbitration agreement and whether the non-signatory was a veritable party. All that it holds further in reiteration of the earlier line of the judgments is that even if a court holds the tribunal from concluding to the contrary after an intent.
What we are pointing.
Yes, just one para, just one. I understood what fell, my lords. Para 34. This does not mean that where the referral court finds prima facie a party is not a veritable party, still the matter is left to the arbitral tribunal.
We are saying the converse. We are saying even assuming the notice is issued to a party who is not a veritable, still the tribunal has the earlier para. The converse is given in para 34.
Yes. So what I am submitting is even the referral court has a prima facie can look at whether this party is a veritable party or not.
Nevertheless, the tribunal can also look.
Definitely.
What is that?
Yeah, I will not dispute that.
How much is the dispute?
About 50 lakhs, Lordship.
About 50 lakhs.
Yes.
In Delhi only?
It's in, venue is Pune. Pune.
Pune.
But can I come? But just one more issue, Malats.
Yes.
This arbitration agreement, the arbitration clause is provided in an MOU where it is said a new partner is being inducted and a supplementary partnership deed will be executed. That deed was never executed. So that person is not a partner. And my lord, everywhere they have used the word partner, I just want to make it a point. Their party and the partner is the same thing.
All these issues can be addressed before the tribunal.
My lord, when partnership is there, the entire arbitration agreement goes, my lords. That is my respectful submission, my lord.
Let my learned colleague argue that before the tribunal. Let the tribunal decide on its own jurisdiction and the merits.
But all of this can be saved, my lords, my lords.
All contentions will be left over.
Both the question whether there is an arbitration agreement between the parties and whether there is an arbitrable dispute, both will be gone into by the arbitrator.
The concluded contract, you mean to say. There is no conclusion.
My lords, if I may make a submission, I requested for a sole arbitrator. There was some issue which was raised by the opposite side.
There will be one sole arbitrator. Retired district judge or some advocate.
Yes.
Obliged.
The amount is 50 lakh.
Yes.
Good.
Item 39, there is a letter. Item 40.
Election. What Lord Council is there?
Last time, my lords,
Somebody took time.
somebody took time saying that they'll file a counter last time. I think they filed something.
That was before, not after that.
19 July.
Last order was on.
Filed any?
Nothing.
Application should be favorably considered, but your lordships, we've now been caught in a web of bureaucracy of approaching different authorities. So I have the various communications that we have sent.
We will be taking admission. You said you had taken the pre-KG.
Your lordships had said that I should apply for nursery. I have applied for nursery, But however, what is happening now is between the local authority, the state authority, and the school, they are sending me in circles, Your Lordships, about who has to take the decision for admission. So there are some communications, if I may hand across the communications that have been sent. There is a local authority under Section 9 of the Act who is also respondent number 9 in this matter. Can I please pass this across, sir? Can someone please take? Thank you. So,
You're appearing, who is appearing
For the state of Maharashtra, Ms. Rukmini Bhopre is on the.
Who is there?
Lordships, I'm appearing for the state.
if Your Lordships may kindly have page 2 of this compilation that I've handed across. This is the communication from my instructing lawyer to the school and to the education officer primary Zilla Parishad. That's respondent number 9 in the present SLP, who is the local authority under the Act.
Yes, Ms. Bogde, what steps were taken by the state and the school with regard to the request for pre-nursery admission?
Lordship, I'll have to take instructions in this matter.
Take instruction. In the meantime, ensure that the child is admitted to the school to which she has applied for pre-nursery admission.
Which school are you asking for?
Your Lordship.
Bharatiya
Bharatiya
Vidya Bhavan.
Vidya Bhavan, Bhagwan Das Purohit Vidya Mandir.
And that this reservation quota.
Your Lordships, yes, Your Lordships. They have RT. Your Lordships, there was initially a rule in Maharashtra that it had to be within 1 kilometer. Now the Honorable High Court has in fact said it should be up to 3 kilometers. But the difficulty in my case was, so the elder child is in the school, but when I applied for the younger child, the residence we were in, that was dilapidated and needed to be renovated. So we had to move out. So when they came to do the inspection, they said, you're not actually living here.
So this kind of objection may come, that's why I was asking.
Yes, Your Lord.
Anyway, the court is passing certain direction.
I'm grateful, Your Lord.
State constitution granted to fight the government and with instructions regarding compliance of order dated 10th August 2026. Meanwhile, however, owing to the urgency for the child's admission to school, committee directed that the petition shall be admitted to the school where he has applied for admission. Be admitted to the school where he has applied for admission. The compliance will be filed.
I'm so grateful, Your Lord. So good. Grateful, Your Lord.
Yes.
I beg to appear for the High Court of Kerala. 22 millards, I may be granted a little time to file a rejoinder, millards. No, milord, only 2 weeks time to file a rejoinder, millards.
Para 1 of the judgment.
What do we want, Mr. Chidambaram?
No, you said the inspection. The High Court.
Just 2 weeks time to file a rejoinder.
I am here to receive the cross.
Transfer. Now,
I'll file a rejoinder, milord, 2 weeks time.
And policy for the petition section granted 2 weeks time to file rejoinder.
May it please your lordships. My lords, a very meritorious candidate, my lords. He stood 8 out of 1791 people in the examination, my lords.
new case without it.
My lords will see that I'm extremely meritorious, my lords. I've woefully low marks in the Viva Voce, my lords, which was conducted by an improperly
Which the point is that, please appreciate, the sitting High Court judges are conducting the.
That is right. May I just say this, my lords? There are vacancies. There were 101 people, 101
Point is
vacancies.
not a vacancy, point is of that if the candidate is, High Court doesn't find suitable, then what we
Yes,
to
but
do?
the
For a suitable candidate, we can ask them to create a
Because
vacancy.
see, then the legal point that I raised was that it was an improperly constituted selection committee. The selection committee, my lords, came after my lords.
Can you, Mr. Palli, can you consider something?
Lord, I have to take instruction on that. Lord, basically, the training is over. They have been sent to posting, Lord. Now, after 2 years, Lord, taking him back, Lord.
It's not 2
And
years.
Lord, it will
Training
open
is
up.
still going. They've said in their counter that training is still going on.
Lord, now, Lord, reopening the matter means those who were there in the interview in his list, my Lord. That will not come up, Lord, one after the other. Because what is not 6 persons were there in the committee. All the 6 unanimously resolved, Lord,
No, no, 6.
majority will prevail, Lord. 4
6 were
of
not
the
there.
members were there, 3 judges, Lord, and
No, we are not impressed by this ground that because the Advocate General or so and so
Yeah.
are not there.
But
No,
this
no
way,
prejudice is caused to the.
it will be unending process, Lord. Interviewing 500 persons, Lord, it would be.
My lords, a candidate is here. My lords, back, my lords, because he's
And this
very
is second
meritorious.
round, my lord.
Out of 1971, I've got 513.
I'm not this second round, Lord. Initially, he came up with the Lord plea that this is a 506 is not, Lord, beyond the rules. Now that after Lord discussing that, he is fresh petition that law, the committee is not properly constituted. Lord,
But
this
let them take
full
instructions,
committee,
my
Lord.
lords, if it's possible.
And that way it will never happen.
Candidate who will be lost to the judiciary is.
High Court is the High Court.
There are, my lords, there are three orders where in similar situations, my lords have asked either my lords pass under 142 to grant where the parties where the person was meritorious. My lords, there is one fact with respect to this.
Getting 50% marks, Lord. Meritorious is
There is a Diksha Khalsa who is in scheduled caste zone, my lords. My lords have directed.
Madam, please, Matthew, I
There are
think we
3 orders.
don't think that there is any direction by us for a candidate who is not found to be qualified candidate. For a qualified candidate, yes, there are certain occasions where we have been issuing directions. Here, unless you are again interviewed and you are made to qualify, the problem is there. We understand, we have full sympathy. What we can do at the best is make a representation to the High Court. We request the High Court to consider.
In fact, in its very same matter, my lords have directed the High Court to consider. Then my lords will then pass the same order, but it might be done in a month. Or my lords will see this ordered in Diksha Khalsa.
Can I have a copy?
Yeah, please give him.
Because problem is in your case is not a question of appointment, it's a question of re-interview.
Re-interview, Lord. All those persons who were there in the list, Lord, they all have to be recalled, Lord. And then, Lord, to be honest, on 30th September.
Challenged. I'm the only person who is before court. There's nobody who had more marks than me who has not been appointed, my lords. The 7 people above me in the, my lords, will see page para 3. Para 4, my lords, we request the High Court to consider the representation sympathetic.
You said High Court.
In 188,
Lord, there 455 candidates were there, Lord.
There are
455 candidates.
vacancies, my lords.
Lord, I would have thought not that, but 455 candidates who were interviewed, Lord, and recalling and interviewing, Lord, and then it is not on this particular, there were 4 persons, Lord, interviewing. Not because the interview went up from 30th September to 1st October. It is not 2 weeks, 3 weeks, they're all interviewing, Lord, it will be a huge.
Because my lords under my.
Not eight rank of not only 50% marks was recorded in written test. 500 out of 1,000. That's saying not 8th rank or whatever. I have nothing against personally, but now it can't reopen the High Court. Twice High Court has gone into the.
How old is he?
And he has applied for Delhi also as per that.
He's a brilliant child. You see, let's not demoralize him. Next time he will definitely make it. Earlier apprehension of these children was that their 3-year condition begun. That on Friday we have relaxed that condition.
1 year.
Now he is already qualified. The moment now exam will be held, he will appear and he will qualify. We are 100% sure. Because sometimes first interview, children do commit mistake. I have also been interviewing candidates. Hundreds and hundreds. So more than almost 400 officers I know that I have selected.
My lords had started off with the High Court. Let the High Court go back and seek whether it is possible, my lords.
Merit has appeared twice, my lord. Twice has been.
Because my lords will see this.
There is a
See how
meritorious
how it
candidate.
tested.
You are getting a meritorious candidate.
Not meritorious, not saying meritorious, not 50% marks.
No other contenders.
Out of about 1,500 marks scored, my lord.
No.
Saying I was 8th rank, I was meritorious. That's why, my lord, in the interview, he couldn't, my lord, make it to be honest, my lord.
My lords could, my lords.
Saying that meritorious and all that.
And my lords will be convinced about his suitability.
Commissioner has not been able to make it to the commissioner could not make it to the arena judicial services. Bracket civil judge, bracket entry level. Due to the fact that out of 200 marks in Viva Voce, he secured only 29.75 marks. He performed well in the written examination, written in bracket main examination. The High Court wide influence judgment is justified in rejecting the petitioner's claim in a way for a re-interview. In the absence of any legal error, we are also unable to interfere with the influence judgment. All that we can observe is that the petitioner may submit a representation to the High Court on administrative side, which may be sympathetically considered.
Much obliged.
There is a committee, the moment you will make which at least this was functioning, we are.
Because this has not been decided as yet. That's why I'm saying.
So they will decide it immediately.
Lords will say in 2 months, my lords.
Much obliged.
It's not appropriate to tell the High Court to decide in a particular manner, but we are quite sure that.
Or expeditiously, my lord might just add expeditiously, my lords. Expeditiously may be added so that. Obliged.
Obliged.
Correct. The satisfaction नहीं, but accord तो हो गया.
How much time it will take, Mr. Diwan?
Because it will take a little bit of time, and I'm a little in an awkward spot because I'm on my legs in a parthard in another court.
Better then we will take up on some non-miscellaneous.
Yes, sir, Your Honor.
Because my only request is one, since your lordships, I'm instructed to say and indicated that in the meantime, let nothing happen in the arbitration is not proceeding. So any time that your lordships at the shortest can accommodate us is all that I can request, my.
You are sure. On a non-miscellaneous.
As I seek to mention. I seek to mention, if my lords permit, I'm so sorry. The matter before court 11 today, they did not sit, my lords. I requested the learned registrar for tomorrow. The bench is not there tomorrow. I'm constrained to mention here. As I requested the registrar for tomorrow, there's an urgency. They said the bench is not there tomorrow, therefore I'm constrained to mention here, my lords.
So it was before court?
It's before court 11, my lords. But I have an urgency for tomorrow. Please, they did not sit today, and they're not there tomorrow is what I'm told.
Some family member got.
Yes, my lords. So, my lord, please consider, my lords. I'm so sorry to mention while my lords are rising.
No, it's all right. Let us examine it and.
I'm grateful, man.
If there is no extraordinary urgency, we can sit on.
I submit the urgency. This is a graveyard. There is a function have data. They defile the graves. They dug the poles in the graves. They cook food over the graves. And I put photographs also in my SLP showing what happens. This is the urgency, man.
Really.
Grateful.